Okay, so it looks like we all found the right location and the right room so far. So this is an adjustment for, ew, this microphone does seem a little vibrant. How about now? Is that better? Okay. So we all found where we're at in our new building, so I'm glad we were all able here to make it. I'm going to go ahead and call this meeting to order. This is our 5th meeting for the Joint Interim Judiciary Committee. With that, we do have a few members that will be participating virtually, and then those of us that are here. So with that, Ms. Jacobson, will you please call the roll?
Senator Harris,
Here.
Senator Krasner, Senator Scheibel,
Sark here.
Assemblywoman Gallant,
Here.
Assemblyman Gray, Assemblywoman Marzola,
Present.
and Chair Miller.
Here. And please mark Assemblywoman Gonzalez and Senator Krasner absent excused. And we have Assemblyman Gray. He is, I don't know where I'm looking. I'm just like, there's so much happening over here. Please mark Assemblyman Gray present. We know that it's just some technical, they're trying to get him logged on, but he will be participating. So please mark him present when that connection's made. With that, we have a quorum, and we will continue with first some housekeeping items. Again, we all know that agenda items may be taken out of order, or 2 or 3 may be combined. We also have meeting materials that can be accessed through Nellis on our website. Committee members will be using our laptops as well as all of these additional screens and monitors and everything that's happening up here. So please don't take that as a indication that we're not engaged or paying attention. It's just as we're going through different things and research as well. At some point today, we will take a 30-minute lunch. We're happy to announce that we brought you to a location that has a lot more restaurant variety and a lot closer to us as well. I ask that you turn down anything that will make any noise on your cell phones or laptops, not so that we're just not disrupting folks. Also, the restrooms are right outside the door if you missed that when you came in. We will start with our first agenda item, which is public comment. Again, we'll have public comment at the beginning and at the end of today's meeting. You can make public comment a variety of ways by calling in or emailing the comments to the committee. We ask that you try to keep your public comment brief to around 2 minutes. And if it's longer than that, we do welcome that you send your full comments in an email to us, and that we'll get to each individual legislator. Those who are interested in calling in, please dial 1-888-475-4499. When prompted, the meeting ID for today is 812-6374-3353, and then press pound. Broadcast and production services staff will indicate when it's your turn to speak. Also, if you do want to email those comments, you can email them to judinterim@lcb.state.nv.us or mail to the Research Division at 401 South Carson Street, Carson City, Nevada, 89701. And of course, all of this is also listed in detail on the agenda on Nellis. And so with that, I would like to open up for public comment. So broadcasting, please open the lines. If there's anyone here in Las Vegas that would like to make public comment, please approach. If there's anyone there in Carson City, is there anyone there in Carson City? Well, if there's anyone there in Carson City, they can approach if they like to. Oh, wow. Okay, so if you would like to approach in Carson City, again, is there anyone here first in Las Vegas that would like to make public comment? Okay, not seeing anyone, then we can go ahead and Carson City, please proceed.
Good morning, Chair Miller, members of the committee. Tanya Brown, TONJA-BROWN, Advocates for the Inmates and the Innocent. We know that next month, this committee is going to be hearing recommendations, and we are asking that you consider our recommendation that we have already provided to you to establish a petition for factual innocence posthumously. We've also provided you today with some documents. I know that that you will be getting some opposition on the recommendations. That's pretty much normal. We don't know what the recommendations are, but we know that there will be. So I kind of want to nip it in the bud right now, because I know that you will in our particular case, because it's happened in the past. And I just want to say that I'm very fortunate, as in part, when compared to most people whose family has lost a loved one and have remained vigilant on trying to prove their innocence. But in the process of doing so, I have gotten some public officials to go out of their way to misrepresent the facts of the case, and
Except that her brother was
this is
involved
here.
in this, Nolan Klein. You got to start with the case. This was a very nasty case. He was convicted for holding two girls hostage who were nothing. They were just selling shoes at a shoe store. Held them hostage in the back room, raped them each several times, burned them with cigarettes, tortured them, did a lot of bad things. He was convicted after a jury trial and sent.
I played that because that was played to thousands of people, and not one thing that he said was true. This type of information that is being broadcasted media to the legislature, things like that, in this case is not. And the segment after this is what resulted in the Honorable Judge Brent Adams issuing an order for Dick Amick to turn over the entire file in the case. When the file was turned over, all the exculpatory evidence was there. The handwritten notes of the prosecutor to find a court order. And as you've heard in the past, I actually found the real perpetrator of the crime 2 years after his death. I have gone through the whole process. The only thing left is this committee to accept and pass our recommendation so that people like myself and other families who have lost a loved one being given the opportunity to continue to exonerate their loved ones. Thank you.
Thank you. And just so that I feel a little awkward as we're getting, as at least as I am personally getting adjusted to this physical environment, that you're used to seeing us kind of look up at the screens when we're in Carson City, but we have these screens now. So if we look like we're looking down, we are still watching, because this screen right here, this monitor, is also showing us what's on that big screen. So please don't think that we're not paying attention during, it's actually more comfortable for me to look down. So do know that in Carson City, we're still seeing you. It's like county commission, I believe, they have these fancy, yes. So thank you for that. With that, is there anyone else in Carson City who would like to make public comment? Okay, not seeing anyone. Broadcasting, will you open the lines, please?
Thank you, Chair. If you would wish to participate in public comment, please press *9 now to take your place in the queue. Caller with the last three digits of 556, please press *6 to unmute yourself.
Anne Marie Grant, ANNEMARIEGRANT, on behalf of Advocates for the Inmates and the Innocent. I'd like to talk about the Washoe County CIC unit and use it to exemplify why a posthumous exoneration factual innocence bill is what is best if we are seeking true reform of our justice system. I requested data from the CIC in June of 2020 for the number of cases that had been reviewed since its inception in 2018, and was told there was only one request. From Tanya Brown in August of 2022, I put in an additional request for an updated number of cases reviewed since 2018. I was told two had been reviewed, Nolan Klein and Tyrone Wells. The stark difference in the two cases that were handled by the CIC unit is telling. While there was no alleged prosecutorial misconduct, aka Brady violations or withholding of evidence in Mr. Wells' situation. His case got a thorough review. Klein's did not. I was truthfully shocked at District Attorney Jennifer Noble's clear resistance to having SB 354 when it was up for factual and is posthumously added to the bill. What is the point of having a CIC unit if they aren't going to truly investigate the case? If Jennifer Noble stated in Klein's case, the CIC cannot offer a more thorough assessment of your claim than the 12 citizens that served on the jury, a jury that didn't get to see all the evidence, by the way. She also stated, ours is structured a little differently, and if any member of this committee has any questions about how it functioned in the review of Nolan's Klein's case, the deceased sibling of Ms. Brown, I would be happy to answer those questions offline and share any communications and evaluations. By the way, that information and data has yet to be shared 4 years later with any of the legislative committees. As Klein's attorney, Treva Hearn, asked, if she isn't going to look behind jury decisions and appeals, what is the purpose of her committee? Truthfully, to me, it appears to be a dog and pony show and further proof as to why we need legislation on this. If you, as the legislatures, don't hold them accountable, they never will be held accountable. With a posthumous exoneration factual innocence bill, the wrongfully convicted would not have to rely on the unrealistic expectation of ensuring the same agency that perpetuated the injustice makes a sincere, honest attempt at independent fact-finding of the wrongful conviction. Thank you.
Thank you. Broadcasting the next caller.
Good morning. Could you all hear me okay?
Yes, we can.
Good morning, Madam Chair Miller and Vice Chair and everyone in the committee. This is Dora Martinez representing the American Council of the Blind. First, I want to thank you, Madam Miller, for all that you do and the hardworking interim committee. Today is the 34th anniversary of Americans with Disability Act. I want to thank the City of Reno Mayor and the RTC Director, Bill Thomas. First time ever today, rides are free for all RTC services and transit services, and we hope this can be statewide so everyone with disability can take the ride for free. I'm sorry, I have a background noise. I was getting my license at the DMV, but I think with Eric Jimenez's release, I couldn't find my car where it was parked, so they gave me a real ID card instead. I just want to thank all of you, and please, if Director Catherine Nielsen will be presenting, she is one of our champions, and we thank her for all of her hard work, and all of you legislators for doing the right thing. And I know it's hard for you guys to sit there and listen to positive and negative things, but we appreciate you all and your services. One thing that I need to bring to the attention, and I heard the agenda was a lot of judges on the agenda. The other day, my friend who is blind went to the court, and there was a touch screen computer system. And if she did not have her sister to help her, it would have been inaccessible to proceed and people to help them out. So I would really encourage that department to, ask to help them make their computer system accessible, because it can happen. And thank you, Madam Chair and everyone. Please stay hydrated, and thank you for all that you do. Happy ADA Day. Take care.
Thank you. Next caller.
Chair, you have no more callers wishing to participate at this time.
Okay, thank you for that. So then I'll go ahead and close public comment, and we will resume public comment at the end of today's meeting. Our next agenda item is agenda item 3, which is the approval of the minutes for the meeting on April 26. Members, I trust that you had an opportunity to review those minutes. They were emailed to us. Are there any questions about the minutes? All right, not seeing any. I will entertain a motion to approve the minutes from the committee meeting on April 26, 2024.
So moved.
I have a motion from Vice Chair Scheibel. Is there a second?
Second.
I have a second from Assemblywoman Marzola. Any discussion, members? Not seeing any. All those in favor, please say aye. Aye. Anyone opposed? Thank you, Assemblywoman. Anyone opposed? Okay, the motion carries. With that, we will move on to our next agenda item, which is a presentation by the courts on adult and minor guardianship in Nevada. We have the Honorable Tamitha Schreiner. Please correct me if I am pronouncing these wrong. Is it Scheinert or Scheinert? Schreiner, okay. Who is the district judge, second judicial court from the Family Division, Department 14 in Washoe County. So if we can't see Carson right now, we also have Honorable Egan Walker, District Judge, Second Judicial District Court for Adult Guardianship Division, Department 7, Washoe County. And then we have the Honorable Denise Gentile or Gentile? Gentili, okay, I like that. I was gonna say I like that no matter how you pronounced it. It's your name, you say it the way you want, right? District Judge from the 8th Judicial District Court, Guardianship Compliance Division, Department F, Clark County, and Stacy Anderson, who is Assistant Court Administrator, Family Court, Clark County. So my first question is, because we cannot see Carson right now, are all 4 of you actually presenting and the other 2 are in Carson? Okay, so. Okay, we're just waiting a few moments because we can't see Carson City right now. This is only our what, 3rd interim meeting that's occurred in this beat? Oh, 2nd. Okay, 2nd. So the first one was what, just Wednesday or Wednesday? Okay.
Chair, give us a moment. They should switch,
Yeah.
so you guys can go if you'd like. The camera will switch to Carson.
This is new too. You're just like talking to us from wherever in Oz or something. This is interesting. Oh, there you are. They're in the back. Look at them. It's like, wow. This is really, yes. Okay, we're waiting. I'm just sitting here thinking of everyone. Oh, we almost, wait, where's Carson? I don't.
I think when they start talking, then
It'll
the,
switch
then the
automatically.
camera
Really?
goes to them.
So let's just.
I think it's worth trying.
All right, we're just gonna let you try. These minutes are gonna be wild for this meeting, so. All right, let's try it. Go, please proceed whenever you're ready.
So good morning, Madam Chair. Can you hear me? This is Egan Walker talking.
Yes, and we can see you. Awesome.
So good morning, Madam Chair. It's a great privilege to join you and the other committee members. I bring welcome from the guardianship bench and our collateral colleagues across the state. We choose this morning to give you some information about adult and minor guardianships, and in order to best do that, I want to give you some background. And so let me strike a somber tone for a Friday morning, and I apologize in advance, but it's an important tone for our conversation. Wednesday of this week, in one of my duties as a district judge in Washoe County, I had the privilege of conducting a sentencing for a gentleman who attempted to burn his former girlfriend to death. And that sentencing resulted in a prison sentence on the maximum end of 70 years. Yesterday, I conducted an adult guardianship calendar in Washoe County and had the privilege of granting guardianship over 3 adult human beings. That's a fairly average number each week for guardianships in Washoe County, for adult guardianships. And the point I intend to make by this analogy is that the gentleman who I sent to prison on Wednesday for a very violent crime retains more constitutional rights than the people who are protected persons under the guardianships I granted yesterday. Why? The gentleman who goes to prison can still sue in his own name. He can marry. He can possess property. He can consent to medical treatment. He can refuse medical treatment. As I indicated, he can sue in his own name. And the people that I served yesterday can do none of those things after a guardianship is imposed. And it's important to understand this lens through which we view the very vulnerable people we serve in adult and minor guardianships. Because you can either view those people from a paternalistic perspective, like you need a guardianship, therefore we're going to impose one on you, or you can view them through the lens of person-centered service. Do you need a guardianship, and is there any alternative? I'd like to share with you a little bit of the history about why that lens is so important. So prior to 2014, I've had the privilege of being involved with guardianship since 2009 as a judicial officer. And prior to 2014, it was literally very much the Wild West. My friend and colleague, Judge David Hardy in Washoe County, who's authored a seminal article that's cited across the country about guardianships, brags still to this day that he could get a guardianship imposed over me in front of any of the then sitting judges in the district just by showing up with a petition. And it was an unfortunate consequence of this worldview that if you need a guardianship, we're going to give it to you whether you want it or not. In 2014, and then particularly in 2015, the world got kind of turned on its head here in Nevada. There were a series of very high-profile cases out of Clark County and out of Washoe County as well, where protected persons in guardianships had been abused in a variety of ways. Their property had been taken without due process. Their families had been disconnected from them without due process. And it created a number of very high-profile, appropriately high-profile incidents. That spurred the Nevada Supreme Court and the Judiciary into action. Justice Hardesty stood up a guardianship commission that I was privileged to be a member of, and that commission met 15 times in 2015 for the purposes of understanding how is it that we got so out of line in the worldview that we would strip people of their constitutional rights more than if we sent them to prison without real protections. In 2016, that commission released a report, a very detailed multi-hundred page report outlining recommendations for changes to the legislature and for changes to the system. You all, meaning the legislators, then acted in a very large piece of legislation in 2017 that carried forward some very significant changes. So among other things, a group of us had the privilege of crafting a new chapter of the Nevada Revised Statutes, Chapter 159A, to control minor guardianships. We included provisions that require the appointment of counsel. Imagine, of course, in our criminal justice system, no one gives a second thought to the idea that the gentleman I sentenced on Wednesday has a court-appointed attorney. But until 2017, in the legislation in 2017, the people who I served yesterday and imposed guardianship over didn't even have attorneys. And so we created a civil Gideon right to counsel through you all in 2017. We stood up a guardianship compliance office. We have a remarkably good compliance officer and compliance officer you're going to hear from in a few minutes. And they provide services to the judges throughout the state for investigation, for financial forensics, et cetera. The New Yorker highlighted, really made a lot of hay about some of the poor things that were happening in guardianship practices and in Nevada in particular, in a very famous article called How the Elderly Lose Their Rights. And again, the theme of the article was to point out how many of those constitutional rights get stripped from human beings when they're the subject of a guardianship. A permanent statewide guardianship commission was established, and I had a privilege of being a part of that and every commission since. In 2018, the Supreme Court adopted a series of rules further clarifying and enhancing court procedure, requiring that I actually physically see the human beings who are subject to a guardianship at least every 3 years. Imagine that we would actually see and assure that people are alive and well and their needs are being met. Lifting restrictions on ex parte communications. It is a tradition in the judicial system, of course, that nobody be able to just call the judge on the phone and say, hey, judge, I'd like to talk to you about my case. But there are some emergencies that arise. A famous example is I had a protected person on my docket who became pregnant. The issue of her pregnancy was very high profile because the pregnancy was very high risk to her and very high risk to the developing fetus. And there was no way for the public guardian's office to give me an appropriate notice of this emergency. The baby's growing every day without an ex parte communication. And so we lifted some of those restrictions. There were requirements, again, confirming the requirement for representation of protected persons, how cases are terminated, and providing mediation services. In 2019, the legislature carried forward amendments to 162A to bring a statutory codification of what are called less restrictive alternatives. We have learned that in many cases, persons who may have limitations to their capacity still retain many abilities. They still can tell us who do they want to live with, where would they prefer to live, what literally would they like to eat, what are the medical interventions they would like, and we can enable, lift up their individual desires short of a guardianship through tools like less restrictive alternatives. And we wanted to share just a bit of that history with you so that you might understand as we enter this legislative session, the chapters that exist, 159 and 159A, have been vetted and very vigorously vetted over time so that we have a robust set of rules with which to provide services to the citizens of the state. I'd like to invite my colleague and friend, Judge Schreinert, to sort of move next in our presentation.
Thank you, Judge Walker. Gonna see if the magic of the microphone switches us. Not yet. All right. There I am. I'm Judge Schreinert from Washoe County, and myself and Judge Gentili from Las Vegas will be taking on the next portion of the presentation, along with two of our staff here in Washoe County and one in Clark County. And so I would invite Jonathan Bai and Mallory Nelson to join me as we will have the staff. They are our case compliance specialists in guardianship to be the ones to actually give you the numbers. And I will just make a couple comments, and you'll hear from me in a few more slides. I'm very privileged to speak to you about this important topic. I became a judge 5 years ago, and for 5 years have been handling all of the minor guardianships in Washoe County. And it is a very difficult docket that brings heartbreak and delight. And I'm so pleased that you're taking an interest and that we can give you this information. I think Judge Gentili also wishes to offer some comments prior to jumping into these slides. Judge Gentili?
For the record, Denise Gentili, Clark County District Court Judge, Family Division. It's a privilege to participate in today's session and to present with my esteemed colleagues, Judge Walker and Schreinert from Washoe County and Ms. Stacy Anderson and the other compliance officers in Washoe. About me, my present judicial assignment is 1/2 of all adult guardianship cases in Clark County, along with the domestic caseload. From January of 2021 to January of 2024, I was assigned only adult and minor guardianships, so I've had experience handling both case types. Also, I wanted to note that Judge Schreinert and I were appointed recently by the Supreme Court to co-chair the Nevada Guardianship Commission that Judge Walker talked about. And I look forward to working with her, the commission, my colleagues, and the community stakeholders in addressing issues that need attention in Nevada's guardianship system. So to provide a little context about adult guardianships, we are tasked with determining the need for the guardianship, ensuring that the guardian is qualified to serve in that capacity. And then when a guardianship is granted, we evaluate and approve care plans for the protected person. We review and approve budgets. We direct management of assets and income with goals to ensure that the protected throughout the guardianship. The adults are also represented by counsel, as he mentioned, through the entirety of the guardianship. That ensures their rights are protected, and such representation is a benefit afforded to the adults as a result of that 2017 legislative reform to the guardianship statutes. As the guardianship remains active, we must ensure that the protected person's needs continue to be met. We analyze annual reports about the person's health and welfare. We evaluate annual accountings of their assets and income to assure the monies are handled properly. We address any problems that arise with the protected person medically or financially. We have the support of investigators who often address allegations of abuse or malfeasance by the guardians. And those investigators are of assistance to the court in determining whether the guardians continue to perform their duties in caring for the protected person's health, welfare, and in management of the monies. Because guardians are vested with the responsibility of making those major life decisions on behalf of the protected persons, sufficient monitoring of these cases is of critical importance and is required by statute. So as it pertains to these slides, slides 5 and 6, we provide statistics demonstrating the numbers of active cases each year for adults and minors, and the number of new case filings as well. And that's the second, I think that's the next slide. Since 2020, you'll see that the numbers trend upward precipitously. And with the increase in open cases, in practicality, it means an increase in hearings, more paperwork, more interfacing with the guardians, more interfacing with protected persons, and an overall increase in case oversight to ensure the needs of the protected persons are met. These requirements are in large part due to that 2017 legislative reform, which really has transformed the guardianship system in an impactful and positive way and ensures that the vulnerable populations under guardianship are better protected. The increases that we see in adult cases are likely attributed to the aging baby boomer population. People are living longer in general. The nationwide increase in diagnosis of Alzheimer's, dementia, all in conjunction with the continued population growth experienced in Clark County. As it pertains to the increase in minor cases, the upward trend is likely due to the same thing, population growth in Clark County, as well as the lack of resources for parents, social services, economic and mental health resources. And further, internally, we've improved our processes to account for each minor individually rather than a sibling group from one family, which is the way we did it before. So the numbers are more accurate since 2022. And as of July 1 of 2024, you'll see that the 2 adult guardianship judges manage approximately 3,930 active cases, which means 1965 open cases each, which is a caseload increase of about 20% from 4 years ago. It's pretty significant. The 2 minor guardianship judges manage about 3,300 active cases and 1,650 each, increase of approximately, I think, 10% from 4 years ago. And that's in addition to our domestic caseload. So you can imagine it's a pretty significant load. For some context, the statistics will demonstrate there are more new guardianships every year, but there isn't a corresponding closure of an equal number of cases. So it always is increasing. For example, when an adult guardianship opens, it closes for only a few reasons, but most case closures are due to the death of the protected person. So that means a case could be open for many years and sometimes decades. For minor guardianships, they are different because the guardianship ends when the minor reaches 18 by operation of law, but the minors still may remain active for many years, depends upon when it's granted, right? So as you can see, the caseloads have grown each year while the judicial resources have remained static. But with the concerted effort of our teams, we're proud of our progress in the management of these cases. Everyone has gone above and beyond with their dedication and hard work to ensure that we're implementing the statutory processes necessary to properly manage the guardianships. But given the unrelenting increase in the guardianship filings, the workload will be unsustainable without some resources. Presently, our chief judge, Jerry Weiss, has assembled a committee which is in process of performing a weighted case study to determine the court's needs in all case assignments. And we are hopeful that the court will be able to dedicate more judicial resources to the guardianship cases to ensure that our vulnerable populations are not put at risk. But once again, I must reiterate the same thing. The 2017 legislative reform has made a significant difference in ensuring the rights of those under guardianship are protected and has provided the court with a framework to closely monitor the protected persons and their guardians in the course of performing their duties. We will be discussing at the end of the presentation a few minor changes that will benefit the system, we think. But on the whole, those 2017 changes have made a marked improvement. And I thank you. Yield to the next presenter.
I believe it's our colleague, Zip.
Okay, that would be Judge Schreiner.
Thank you. Yes, so we'll come back to Carson and have Mallory Nelson is going to discuss the numbers of adult guardianships here in Washoe County. And go ahead.
Good morning. For the record, Mallory Nelson. The numbers in Washoe County for this time period show that active adult guardianship cases, they've stabilized even with a growing population in Washoe County, and that's for a couple primary reasons. First, during this period starting fiscal year 2020, we just began to more closely monitor the cases in which a protected person had died, but the estate still needed winding up. There still needed to be a final accounting. So With closer shepherding of these cases through the termination process, we are now finding that the number of cases we are closing per year more closely resembles the number of cases we are opening. Second, less restrictive alternatives are widespread in our community in Washoe County, and that's thanks to legislation recognizing things like supported decision-making, powers of attorney geared towards adults with disability, adults with dementia. This provides us more off-ramps in the adult guardianship process, so that just because a new case is filed, that doesn't automatically equate to a guardian being necessary. Our workload is now focused on the rigorous oversight of the cases we do maintain under supervision. And as previously indicated, these cases can last for decades. If there aren't any questions at this time, I will look to my minor guardianship colleagues to speak to the numbers.
Good morning. For the record, Jonathan Bai, Case Compliance Specialist for Washoe County Minor Guardianships. As you can see, our active cases in minor guardianships have consistently been rising. While we do regularly close them for common reasons are reunification with a parent, adoptions, ages of majority, we're still acquiring and keeping cases at a higher rate than we're closing them, and part of that has to do with the increase in new cases. And with that, though, these cases still do require regular management, 3-year review hearings, oftentimes subsequent petitions from parents, guardians, other interested parties that often require hearings, and sometimes investigations. But also for regular items like reviewing annual reports and responding to those, as well as accountings. But overall, as I said, they are we're acquiring the cases, and we are terminating them, and we are making efforts to be on top of that. But overall, they are sticking around longer than they are leaving. With that, I will pass it back to case Mallory Nelson for the new case filings.
And good morning, Mallory Nelson for the record. New filings in Washoe County, they rebounded. So 2021, 22, we saw a slowdown. Fiscal year 23, that's something of an outlier. Crucially, what these numbers are not counting are petitions to appoint a successor guardian in an existing case. Most people under an adult guardianship in Washoe County, they're younger than 50, so those cases are lasting years, decades even. And we see annual filing requirements, review hearings not less than every 3 years. From the court's workload perspective, the process for appointing a guardian in a pre-existing case, it's the same procedure as appointing a guardian in a newly filed case. And with that, I will turn to my colleagues in Clark County.
Good morning. For the record, Stacy Anderson, Assistant Court Administrator in the 8th Judicial District Court. We are pleased to present our compliance rates, as you'll see on the following slides, for both adult and minor guardianships. To give you an idea of some of the compliance things that we track that we believe are really important with the case. You can see that we are tracking both in Clark and Washoe annual report of guardians, which is actually the report of the protected person's well-being on an annual basis, which includes where they're living, who they're residing with, educational attendance, medication, doctor's visits for the prior 12 years, or prior 12 months, pardon me. We also are tracking annual accounting submissions, and these are detailed accountings of protected persons' estates for both income and expenses, so that we can review them from the guardianship compliance perspective to see if there are any known red flags anything stands out so we can advise the bench of the issues. And then we also track closely inventories. So these are required as soon as the guardian is appointed. They have a period of time to submit those into the court. And this is really the baseline for future annual accountings. It shows all of the assets, or it should show all the assets of the protected person, including bank accounts, jewelry, property, cars, investment accounts. So that really, like I said, is the baseline, and then that follows are the annual accountings that we then continue to monitor. All of the case compliance rates that are listed on these slides for both Clark and Washoe are based on our active caselets. So those 7,000 cases right now that are being monitored in Clark County, these compliance rates are based on that. A couple of things to touch base on. In Clark County over the last 5 years, compliance has changed a little bit. Our compliance division has grown. We are appreciative. Clark County recently in 2023 approved for the creation of 2 new compliance officer positions, and they funded them, which is amazing. So that helps us continue to manage and to review these annual filings that are coming in on a regular basis. And it also helps protect our vulnerable population. Some other things that we are continuing to do, or that we've done in the past 5 years, is we still generate notices of noncompliance, especially in adult cases. But in minor cases, we found it's actually more effective to reach out to that guardian to say, hey, we're missing XYZ, and they tend to file it quicker. The guardianship website in Clark County, oh, should I switch? Pardon, we have technical difficulties. To continue, if everybody can hear me, the guardianship website in Clark County was updated during these last several years to make it more user-friendly, to provide better information to guardians and protected people, and as well as frequently asked questions that we commonly get in the Guardianship Compliance Division and the courts, and alternatives to guardianship, which is very important as well. The other thing that we've done is we developed in fiscal years 21 and 22, we developed and released guided interviews. So guardians can go online into our application, answer a series of questions, and it will automatically complete the report for them. And if they choose to e-file it right then, it will e-file it into our cases in Clark County. So it's a really great tool to attempt to increase compliance. And you can see that our rates have remained relatively stable in adults during the last 5 years. But in minor guardianship, let me switch slides for you. In minor guardianship in June of 2021, we did see a decline, specifically in the annual reports that were submitted, and we believe that to be due to the COVID-19 pandemic. That's when schools went online. Parents, were taking care of their families, and annual reports didn't seem to be the priority to be submitted in. But since then, we have slowly started to recover, and I think that's very important with the resources that we've dedicated, not just to minors, but to also adult guardianships, as well as our daily workload managing these active cases. In fact, we're almost back to pre-pandemic levels, which I know that our court is very proud of. With that said, I'm going to pass it back to my colleagues in Washoe County to see if they have any other additions to these slides.
Thank you, Mallory Nelson, for the record. Similarly, after COVID, we worked hard to reestablish communication with our guardians, get them back up to speed. We pride ourselves here in Washoe County on maintaining that culture of compliance. The chief way we do that, again, it's issuing a formal notice of non-compliance into our cases, typically as soon as within a week of these key filing deadlines being missed. We also use less formal mechanisms, automatic text notifications to our guardians about upcoming and past due filings, and also just directly contacting them. That's by phone, by email. Make sure they're aware that there's been some non-compliance in their case and that they know how to access the forms they need. It's with this kind of consistent enforcement and reminders, our June 20 fiscal year 24 numbers are showing our guardians are overwhelmingly responsive to the call of the court. I will let my colleague speak to the next minor guardianship slide.
For the record, Jonathan Bai. So, a brief aside, looking back, another item that we face in minor guardianship here in Washoe County is that our actual new cases are increased year over year, the new filings we're getting, and those do contribute to the amount on these statistics you see regarding the compliance rate. So June 2020 has significantly less annual reports that are being reviewed than the overall number than June of 2024. We have only recently gotten a full-time compliance specialist for minor guardianships. It's been a little under 2 years, so our minor guardianship compliance program is a bit younger. But as you can see, our numbers have been improving overall with our annual reports going up. We've been implementing a lot of the same things that the adult guardianship side has. On our end, we issue formal orders to file a lot for non-compliance issues. We generate lists daily to get those out to cases that are out of compliance. We've also developed our own minor guardianship class to kind of at the onset of someone being appointed guardian, teaching them about the job they've been hired for, and specifically the requirements and paperwork and resources that are unique to Washoe County and what we're doing, as well as some of the things they need to do or can be done to either end it, move, guardianship, those sort of things, just so they know a lot more of their options. We've also been implementing text message notifications for missing documents. So from a few slides ago, you saw there's 1,400 cases that are active. You know, a large part of our compliance part has been adding phone numbers to all of those cases so that they can happen, and also phone calls when appropriate to help get people to get their paperwork and help them out with just simple things on how to find it, because that's sort of something that is easy to forget, is that sometimes people who are only in contact with us once a year might not remember everything that we see every day. One other comment I just would like to make to kind of give some context to these statistics. When you see our annual reports number, that's talking about over 900 instances of that versus the accountings and inventories, which are between 50 and 60. So while annual reports are oftentimes a much more consistent number because it's just simply harder to move, accountings and inventories can be a little bit more volatile just because it's such a smaller number. But in minor guardianship, we're just often dealing with guardianships of the person much more often. So thank you. With that, I will pass it back to our colleagues in Clark County.
Again, for the record, Stacy Anderson, Assistant Court Administrator. On the side that we are reviewing currently, we want to touch base on the investigator appointments that occurred in the last 12 months. For both Clark and Washoe counties, but also as a result of guardianship reform in 2017, the recorder fees that were enacted that have been collected since fiscal year 2018 through current, and some of our expenditures and how we're spending that money, mostly at a high level, just to give you an idea of how we spend it. You can see on the slide that we actually have had 1,428 investigator appointments, which is quite a bit for minor guardianships. However, that number is made up of what we consider to be 3 different types of minor investigator appointments. We have our regular minor guardianships investigations that are usually coming directly from the judge. There's something that's showing up in the petitions or documents that are, they say something that is causing concern during their hearings, and or there's allegations that the judge needs our minor guardianship investigators to actually look into. So that can include obtaining CPS records, sometimes obtaining bank records and other things to determine what exactly is going on in the case, and written reports are actually filed back into the case so that the judge and all the associated parties can see what we found. We also do what we call Rule 10 investigations. Rule 10 is a direct reference to the statewide guardianship rules in Rule 10, which actually allows for the removal of a guardian for noncompliance. But in Clark County, the judge actually appoints a minor guardianship investigator when all of our efforts seem to have failed. So all of our notices of non-compliance, our phone calls, because at this point, we presume that they're missing. Even though they might not be, we haven't had any contact with them. And that's very important because now we're on the mission to go out and find these guardians and our protected people. And we do this specifically for our minor caseload. And the state guardianship office helps us with our adult caseload due to the volume that we have. And the other thing that we do, what this number represents, is 1,065 new minor petitioner background investigations. That's a new initiative that we started in January of 2022. So every new petition for minor guardianship, especially if it has multiple petitioners, we actually do a preliminary background check. We found that it's a best practice, but we found that it actually seems to assist in alleviating issues farther down the road that maybe we didn't know about. And so it's a preliminary background check unless we find something that warrants that we obtain law enforcement records through Metro and/or Henderson PD or North Las Vegas PD. And sometimes we do reach out of state as well. But a report is filed into the case with this information so that the judge has something to speak to with the petitioners and a jumping off point to determine potentially what actually happened, because obviously we don't have that full information when we're doing that preliminary background check. Now, we recognize this is not a money committee, but we did want to show what's been collected in fees with that additional dollar recorder fee that's going to support our minor guardianship investigators. You can see that fees were quickly increasing, and then in about fiscal year 2022, we started to see a slow decline with that. Associated spending in Clark County, the two major things we spend our money on from these fees is minor guardianship investigator salary and benefits and minor guardianship representation, legal representation. Those are our two major expenses, if you will, and they're best practices. So the court is committed to always ensuring that we hopefully have resources to continue those efforts. With that said, I'm going to turn it back to my colleagues in Washoe County so that they can comment on this slide as well.
Thank you, Judge Tamitha Schreiner, for the record. Yes, these investigative fees are crucial to certainly my work as the minor guardianship judge. And as you can see by the numbers, the recording fees are going down and our need is increasing. When do I use these investigators? First, often we'll appoint an investigator when receiving a petition, when we don't have enough information or the petition is itself lacking in the detail. After an initial hearing, I might appoint an investigator when there's clearly more information that the relatives want to tell me that I do not have time at the actual hearing for, or there's background information that I need, such as the criminal records, the school records, any past connections with Child Protective Services. And then we also appoint an investigator when we receive a petition to terminate a child guardianship or a petition to relocate a child. We do get annual reports from the parties, but often we don't know at that point what's happening with the parents, with visitation. So the investigator will reach out at that point to give me information before my hearing. And then, of course, we, as mentioned by Mr. Bai, we do appoint investigators to track down missing reports, to contact guardians who haven't been filing, and get further information. So as you can tell by that breadth of use, this is a crucial piece of our cases. The more funds we have, the more compliance we have, and the higher protections that I can put in place for the children and make better decisions on behalf of the children. So that is our slide on that to look at the numbers. The next slide, if you'll turn to that, is for me to give you a little more context than I've given in terms of what the investigators can do for us, and a couple of examples. I've had a few recently where we do learn that the guardian has either contacted the court, or when they haven't contacted the court and I've appointed an investigator, we learned that the child was moved to a different relative unbeknownst to the court. So the investigators have quickly been able to reach out, find the adult the child is with, do an assessment, do a report, and then we have a hearing. And in at least 2 or 3 of the cases I'm thinking about, we were able to do a successor guardian and get the child those protections they need. We've had our investigators work with other states in getting information. We do have had success with that when we have out-of-state guardianships to get the information. And it's a piece that was so important that was put into place in that legislation in 2017 that we all really appreciate and work with, and one that I wanted to highlight for you as an important piece going forward. I think the next slide is my colleague Judge Chantilly in Clark County. Thank you.
Right, so we have the same assistance with the state investigators. In adult guardianships, we appoint them to either investigate abuse, neglect, like it says, or exploitation. They assist with locating the protected person. Oftentimes, again, we won't have the reports filed, we won't know where they are. So the investigator will go out and find the protected person, and oftentimes they're fine. We just need to know because they haven't kept up with their reporting. But sometimes they're not fine, and then we need to take action to either replace the guardian, maybe appoint the Clark County Public Guardian to step in and do what needs to be done to care for the protected person. Under Rule 10, the statewide guardianship Rule 10, we can't revoke and terminate the guardianship unless we appoint the investigator, determine their health and welfare. So that's part of the process as well, determine whether the guardianship remains necessary. So they assist us in that process. And then also when there's mismanagement of funds, which often happens, they'll perform forensic evaluations on the protected person's estate to let us know what's missing, if anything's missing, or if they're just doing a poor job of reporting. And so they really assist us in many aspects of managing these cases. That's it, and I'll pass it to the next slide.
Thank you, Egan Walker, for the record again. Madam Chair, thank you again for the privilege of speaking. I hope we're demonstrating to you that the judges work collaboratively across the state together with one another in our individual jurisdictions, north to south. You're learning that there's a passing of the torch happening here quite appropriately. The former co-chair, together with myself, Judge Markey, are passing the torch to our colleagues now, Judge Chantilly and Judge Schreinert. But Judge Markey and I literally went to every district court in the state during our tenure on the Guardianship Commission to speak with judges across the state about their needs. And as now you all consider the legislative agendas you all will have to carry this session, we ask you to consider that the Guardianship Commission has been and will be very active. We intend to give feedback and information anytime to either body of the legislature on request. I was very active last legislative session and got to meet some of you in that context, and I know my co-chairs look forward to being very active in this session as well.
Thank you, Judge Walker. This is Judge Schreinert, and I am very excited about going forward with the commission with Judge Chantilly. One of the things that the commission has in the past been involved in, as we discussed already, is the legislature and changes that could happen for adult and minor guardianships. And we are very pleased to let you know of a few things that we are interested in looking at, and we'll be discussing with you further. This slide is just a little highlight. I know we don't have a lot more time, but certainly one of the things that we want to look at is allowing judicial discretion to have the types of service available for other types of cases in guardianships. Specifically, there is Rule NRCP Rule 4.4 allowing alternative service that may be appropriate in some cases in guardianships. Right now, the law is very prescriptive in what we can do. The next piece we want to look at is increasing the funds coming in for those investigators. I think Judge Gentile and I have made a strong case for why that is needed, but currently those funds are decreasing and the need is increasing. Finally, the amendments to allow our investigators to obtain vital records from the Nevada Department of Vital Statistics at no cost. Those are crucial to the court. Those are records of birth certificates, death certificates, and other types that should be readily available from one department to the next to be able to make these orders. I don't know if Judge Gentile wanted to add anything on this slide. I don't have it in my notes. Otherwise, we'd move to the next slide. Thank you.
Egan Walker again for the record. So as we move into the next iteration of the Guardianship Commission, I want to thank my co-chair, Judge Linda Marquis from the 8th. I want to thank the new torchbearers, Judge Schreinert and Judge Gentile, moving forward. And I hope we've painted a picture for you, the legislators, of our ethos. We are at first, last, and always public servants. The folks who occupy these cases, the children and the vulnerable adults, are deeply and profoundly close to our hearts. And we seek, together with you as the legislators who really write the law, to continue to harmonize practice with the needs of the people we serve in this very vulnerable area. It's been a deep and profound privilege to serve as a co-chair of the Guardianship Commission, and I thank you for your time.
Thank you, Judge Walker. As one of the new co-chairs, I will give warm thanks for your service. I attended meetings where you and Judge Marquis ran those meetings and was just amazed about the amount of dedication and time, and traveling statewide really brought us all together at judges' conferences. Everyone is very pleased with the amount of work being put into this area. The Guardianship Commission will be setting up a meeting this fall. Judge Gentile and I will be working with the court to get that set up so that we can let all the stakeholders know when the meeting will be, and we invite the stakeholders to come and present ideas for legislative changes or other goals going forward. With that, Judge Gentile, do you want to add anything on that? Thank you.
For the record, no, I think you've covered it.
Does this conclude your presentation?
Yes, thank you so much.
Okay. Thank you for that. And with that, can I request that you, because so much happens and things get lost, could you send us to the committee a direct invitation to that, to your committee meeting, to your commission meeting? Because I know that this is such a complicated, nuanced, issue that I'm sure many of us would like to participate if we could, or at least listen in if we could. So if you could just send a reminder to us, that would be very helpful. With that, members, do we have any questions? Not seeing any. Assemblywoman Gallant, do you have any questions? And also, was Assemblyman Gray able to connect? Do we know if he's present? Okay. All right, not seeing any questions. I will thank you for your presentation and close this agenda item. Thank you so much. Also good to put names to faces for this as well. Our next agenda item will be a presentation on the activities of the Guardianship Compliance Office. We have Kathleen McCloskey, Guardianship Program Manager, from the Administrative Office of the Courts of the Nevada Supreme Court. And we see you there in Carson City. So give you a few moments to get yourself settled, and whenever you're ready, please proceed.
Good morning, and thank you, Chair Miller, and thank you all for inviting me here to present to you. The Guardianship Compliance Office, our primary function is to provide investigation and audit services to all district courts in Nevada. As Judge Schreiner, Judge Gentili, and Judge Walker have talked about, our investigations inform the court on the well-being of the protected person, their estate, any unmet needs protected people have, the circumstances that have brought the guardianship petition, any competing interests that may occur, and other issues that impact that guardianship case. In all of our investigations and audits, we do issue a report to the court. Our common investigations include location of the protected person when the court has lost contact due to noncompliance, health, safety, and welfare concerns, and what I call pre-guardianship, so those background checks that Ms. Anderson spoke about. We do access records such as educational records, financial records, and other important records, and provide those to the court as well during our investigations. We are a statewide office, so we investigate and audit all guardianship types in all courts. The only exception is that in the 8th in Clark County and the 2nd in Washoe County, as you've heard, they have their own minor investigators. However, we do audits for minor guardianship cases in those districts. Currently, my office has 2 investigators, one located in Carson City, one located in Las Vegas, and I have 2 financial forensic specialists. Again, one in Carson City and one in Las Vegas. So on our next slide, you'll see our appointments to investigate and audit for a 5-year period. The numbers are kind of bouncy. So you'll see in 2019 we were ordered into 254 cases. Then we dipped down in 2021 and then go right back up in 2022, coming down in 2023, and then down again in 2024. The bouncing, I believe there are 3 things that have influenced that. One, in 2018, we had a change in minor investigations, so we did see a reduction in the following year, going into 2019, 2020, 21, as they got their offices and contracts into place. Second, the pandemic. Between 2020 and 2021, you see a pretty significant reduction from 2019. Courts were struggling to figure out how to deal with hearings. Families were taking care of their families and not necessarily reporting. So then in 2022, you see an increase where courts are bouncing back and ordering us back in to locate people and look at people's health, safety, and welfare. And the third influence, I think, is courts have really gotten good at monitoring their guardianship cases in the past 5 years. They've put in really good processes. I think the compliance specialists today gave you a good description of how they've improved their processes and how they're tracking their cases. So I think that we haven't seen yet a true baseline over the past 5 years of what our office will be doing because of those factors. So that's primarily our primary activities, our investigations and audits. However, we have been working on several other projects. In 2021, my office was the recipient of the Elder Justice Innovation Grant, which is sponsored by the Department of Health and Human Services Administration for Community Living. The goal of our project is to develop consistent guardianship practice and monitoring throughout the state, increase access to lesser restrictive alternatives to guardianship, to improve the collection and analysis of guardianship data, and as well to develop a training program for lay guardians as well as judicial officers. So when we started this project in 2021, we first started with a fairly comprehensive assessment of each district court. That assessment, we contracted with the National Center. I'm sorry, I'm on the wrong spot here. I apologize. So we assessed each district court's internal processes, including their case management system and data needs related to guardianship. In addition, because the state currently receives limited data on guardianships on a statewide level, we wanted to assess for the feasibility of developing or creating a guardianship portal in Nevada. And I'll talk more about that portal in a few minutes. And then again, we also wanted to fill a gap in education for judicial officers as well as lay guardians. So with respect to the training, we contracted with the National Center for Juvenile and Family Court Judges, and they helped us conduct a statewide training. They helped us do a training needs assessment related to both types of trainings. Based on this needs assessment, we focused on developing training for judges that include lesser restrictive alternatives, monitoring best practices, overall general best practices in guardianship cases, available services in their communities, and then again, the actual legal process. We've held one in-person training in 2023, and we are almost ready to publish the online training modules for judicial training this fall. In addition, we have worked with specialists in the guardianship arena in developing online training for lay guardians. Currently, our NRS allows for a judge to require a guardian to receive training, but there's been no statewide training available for lay guardians. So this fall, we'll be filling that gap. So that training will be published in English as well as 3 other languages. So our initial assessment of guardianship or court needs throughout the state, we contracted with the National Center for State Courts. The assessment we completed included physical site visits at each district court to conduct interviews with court staff and judges, file reviews, and a comprehensive assessment of their case management systems. In addition to that assessment, the National Center for State Courts did complete the feasibility study related to the creation of an online guardianship portal. That portal will provide a way for guardians to directly enter their reports and accountings, provide courts with an efficient way to monitor guardianships, and issue reminders to guardians, as well as allow for the collection of consistent data across the state. The findings of our initial assessment found that we had improved monitoring in Nevada. So Nevada had put in some best practices. For example, required 3-year review hearings, as well as the use of remote hearings during the pandemic, which have continued, and that has increased participation of guardians and protected people. However, we also identified some needs for improvement, which included improved needs for data collection, the need for more efficient monitoring processes. We need to improve our process of complaints, There has been a lack of e-filing throughout the state, so one recommendation was to improve the ability for families to e-file, create a way to provide reminders to guardians prior to reporting deadlines, and then training for both judicial officers as well as lay guardian training. In addition to these findings, the outcome of the feasibility study found that Nevada was in a very good position to create the online guardianship portal. So the portal is currently being designed, and it's being designed to address the findings in the initial assessment. So for the last year, my office, as well as the AOC IT team, have been focused on designing and building that guardianship portal. So what the guardianship portal will allow for, again, is collection of statewide data, which we hope to be able to feed back to the commission so they can make good informed decisions related to any systemic changes and or changes to ensure that there's consistency across the state in the administration of guardianship. In addition, we're hopeful that the portal will provide district courts with an efficient way of monitoring their guardianship cases. So district courts, judges and staff will have dashboards that will show them automatically what is due, what is overdue. The portal will issue alerts, so there'll be built-in red flags. For example, as the guardian is inputting their accounting information, in the background, that portal will be analyzing the data and issuing alerts based on identified red flags. In addition, we'll have what we're calling an opt-in, where if a guardian opts in, they can have their financial institution directly upload financial information for the accounting directly into the portal. So it'll reduce some work for that guardian. What I've learned in auditing over this past 5 years is the majority of guardians want to do a good job, but accounting can be really hard for a lay person. So the benefit of the portal for guardians will be it'll do all their arithmetic, right? They're going to enter in income, assets, expenses, and it'll do the math for them. So we're hoping to make it a little bit easier on the guardian as well. The portal will issue reminders of things that are due, so that will help reduce, hopefully, some of the time current compliance staff have to issue those reminders. So if they're using the portal, that'll generate for them. That'll allow their compliance specialists to focus on the quality of reporting, right? So we're hoping to make monitoring more efficient for courts, reporting easier for guardians through the portal. So the status of our project currently, for the portal, we begin user testing this fall. Our IT team has done an extremely wonderful job in developing the portal. It looks wonderful, and I'm very excited to see the results of user testing and then piloting it in district courts this coming year. Our lay guardian training in English will be deployed later this summer, fall, and throughout next year we'll be translating that and publishing it in Spanish, Tagalog, and Mandarin, which are our 3 most requested languages for interpretation in courts in Nevada. Our judicial online training will also be published late summer, early fall. So with that, those have been the activities of my office over the course of the last 5 years, and I will entertain any questions if you have them.
Thank you so much for your presentation. Members, do we have any questions? Assemblywoman Gallant? Any questions? Assemblywoman, so you know we're not able to see you the whole time. I know we're still working stuff out, so that's why I just keep.
No, I don't have any questions. Sorry, I'm nodding my
Okay.
head thinking you can see me. I apologize.
Yeah, no, that's why yeah, just so you know, yeah, we can't see you. So thank you for that. Okay, so with that, not seeing any questions, we thank you for your presentation, and I will close this agenda item. Our next agenda item 6, is a presentation on adult and minor guardianship in Nevada. We have Jonathan Norman, the Director of the Statewide Advocacy, Outreach, and Policy from Legal Aid Center of Southern Nevada. We also have Marina Dahlia Hunt, Esquire, Children's Attorney Project, also from the Legal Aid of Southern Nevada, and Katie Anderson, Esquire, the Guardianship Advocacy Project, also from Legal Aid of Southern Nevada. So we'll give you all a few moments to get situated, and please proceed when you're ready.
It is up on the computer. All right, good morning. Thank you so much. My name is Jonathan Norman, Jonathan Norman with the Nevada Coalition of Legal Service Providers. I'm joined by my two colleagues, Marina and Katie. They both are team leads for minor guardianship and adult guardianship. And hopefully I'm just going to be working the PowerPoint. I did want to make one just brief comment. One thing that I think is interesting is, you know, we think of guardianship, minor and adult being similar, but actually in both Northern Nevada Legal Aid and Legal Aid Center of Southern Nevada, our minor guardianship program is nested within our Children's Attorneys Project, which is the 432 Dependency, Abuse, and Neglect. And I know Marina will be touching on the overlap between those two, but a lot of the families coming into minor guardianship are the same families that we see in dependency, abuse, and neglect. And with that, I will turn it over to Marina. Katie.
Good morning. My name is Katie Anderson, Katieanderson. Thank you so much for having me today. I first just kind of want to talk about an overview of guardianship, and the judges did a really good job, so I don't want to belabor what they've already explained, but we want to focus on the fact that our adult guardianship clients can range in age from 18 years old to those who are facing the end of their life. And so it's a really unique area of the law, and our representation starts at the outset of the case. So as soon as the case is filed, we are appointed and we remain on that case and as advocates for that person until that guardianship is terminated, which, as you heard earlier, could be when a person recovers from whatever caused them to be in guardianship, or when that person passes away at the end of their life. So it can be a very long time that we get to know our clients. And we want to make sure that our client's voice is heard by the court, and that our client understands what's happening to them, and that their due process and constitutional rights are protected. Protecting these rights is our priority, and the reforms in 2017, I think, sort of solidified that. That's when it became mandatory for us to be appointed in every single case. And as a result, we have become sort of the primary voice for people who wouldn't have otherwise had a voice prior to 2017. And with that, I'll pass it over to my colleague.
Thanks. Marina Dahlia Hunt, for the record, Marina Dalia-Hunt. So our minor guardianship program within. I'm
you're-
not on, am I? There we go.
There you
Thank you.
go.
Sorry about that. So, sorry. So just as a very basic preliminary matter, when we talk about minor guardianship under NRS 159A, what we basically mean are children who are being cared for by someone other than a parent outside of the dependency system. We do, of course, see children who have somehow inherited an estate or have received a settlement, but the vast majority of our cases for children that we represent are children who have a parent or both parents who are unsafe, unsuitable, or unavailable. So just wanted to situate us there outside of the dependency system. As John mentioned, most of our cases, however, are wildly similar to the dependency cases, which are housed under NRS 432B. I'll touch on this more later in our presentation, but of course, the 2017 reforms, from our perspective, one of the major and most important reforms is that it created the mechanism for permissive appointment of counsel. Counsel is not required to be appointed for children in guardianship, unlike adult guardianship and unlike children in dependency. But through our representation of children in minor guardianship, we've represented thousands of children in this system.
Katie Anderson. Next, I kind of want to dig into a little bit more about what our representation looks like. So in 2023, both the Northern Nevada Legal Aid and our Legal Aid Center of Southern Nevada accepted about 1,000 new cases. And at the end of 2023, the guardianship advocacy programs had a total of 4,000 cases, both old and new, that we were actively working. So that just kind of gives you an idea of how many folks we're helping each year. And we follow what's called a direct representation model. What that means is that we try to maintain as close to a normal attorney-client relationship with our clients. And what that means in practicality is we have to follow still all of the rules of professional conduct, the guardianship rules set forth by the Supreme Court and Nevada law. So if a client is able to communicate their wishes to us at any point during the guardianship, then our responsibility is to fulfill and represent those wishes to the court. But as you can imagine, capacity can be nuanced. So some clients are able to weigh in on more complicated decisions that need to be made, and some clients are not. Some clients are nonverbal. And just because a client doesn't know how to sort of weigh in on those more complicated things, if a client can't give an opinion on how their finances should be invested, doesn't mean they can't weigh in on more simplistic things like where they want to go on vacation. So we try to make sure that we're approaching our clients to make all of these decisions regardless of how complicated they are. If our clients are in an unfortunate situation where they cannot direct us at all, we still have an obligation to protect their due process rights and their constitutional rights. So we're still going in court and advocating to make sure that the people who are in their family that may want to know that a guardianship has been filed, we want to make sure they've all received notice of those proceedings. We want to make sure that all of the other procedural requirements have been met. We want to make sure that every court hearing is attended by our office. So those types of things. And so with that in mind, I next kind of just want to touch on some of the challenges that we have faced and kind of what we are looking to improve for our client representation going forward. And one of the greatest challenges is, as we put in the slide, actualizing the Protected Persons Bill of Rights. So going back to the reforms that happened in 2017, one of the new things that was implemented is something called the Protected Persons Bill of Rights. So that is a list of rights that even once a person is under guardianship, they maintain some independence and autonomy as much as possible in certain areas. That can include the right to attend court, the right to be presented with an accounting of how their money is being spent, a right to participate in the plan that's being made about their care. All of these things we are ensuring that the court keeps in mind and respects along the course of the case. Unfortunately, it's sometimes tempting, though, to think of a person who is incapacitated as unable to have any participation in their own life, because we all are tempted to have this sort of paternalistic view of what we're doing for those folks. So we are tasked with reminding and educating people all the time about how deserving our clients are of continuing to participate and have their opinions about how their life is led respected and kept in mind at all times. So that's one of the challenges that we're always faced. Another challenge that we have is going back to the Protected Persons Bill of Rights. One of the things that a protected person has the right to do is talk to and visit with anybody they want to. But on the flip side, a protected person also has the right to refuse to talk to or refuse to visit with those people that they don't want to visit with. Sometimes that can be more difficult for people to accept. Family often wants to visit their grandma, but we, as part of our responsibilities, are ensuring that people who want to control who comes into their house, when they visit with people, when they don't visit with people, we have to remember that that is a right that is maintained by our protected folks as well. And just because they don't want to visit on a particular day doesn't mean that they might not want to visit on another day. And so we always like to keep those lines of communication open. But again, that's a challenge that we have to face and educate people about. Another challenge that that's really present in our practice right now is the idea of attorney's fees. So in guardianship, guardians who use attorneys to help them in their case are required by statute to pay their own attorney's fees. But there's also a portion of the statute that allows the guardians to seek permission to have their fees paid by the protected person's estate. So instead of paying their own fees, they would submit those fees to the court, and the court would award those fees to be paid out of a protected person's estate. As part of our advocacy, we work to ensure that any fees that are going to be paid from our client's estate are reasonable and necessary. We want to also ensure that the fees that are requested, the attorney's services that are provided, have benefited the estate and benefited the protected person. And finally, we want to make sure that the estate can afford it. So for example, if a person has $200,000 and that amount of money is what's meant to help them take care of themselves for the rest of their lives, but then attorney's fees are awarded and suddenly $50,000 is gone, then that's that much less that protected person has to pay for their ongoing care. So we want to ensure that the estate of the protected person at first and foremost is used for that person's care, because that's what they saved it for. So if the estate is depleted by attorney's fees, again, that just means that there's less left over for that person to take care of themselves. Finally, and this is a sort of a less common example, but another challenge that we have that we're kind of looking toward trying to solve in the future is having the right to appeal life-altering decisions that are made by the court. So right now, there are only certain court orders that have the finality to allow them to be appealed. But the court does have the power to make other decisions about a protected person. For example, if a protected person is going to be moved by their guardian out of state. That would be a decision that would need to be presented to the court, and the court would rule on that. Or if, for another example, if a guardian wanted to sterilize their protected person under their care, that would be another decision that the court would need to make. Unfortunately, though, neither of those court decisions are appealable. So let's take the example of moving. Let's say the protected person doesn't want to move. The guardian has presented this proposal to the judge. The judge grants permission to move against the wishes of the protected person. We, on behalf of the protected person, have no ability to appeal that decision. So those are things that we just want to keep in mind as we look toward the future and want you to be aware of, that are sort of pitfalls that we deal with in representing our clients. Thank you so much for your time.
Okay. Marina Dahlia Hunt for the record. So similar to what Katie mentioned, we also have a relatively hefty caseload for minor guardianship cases. In 2023, we opened over 600 new minor guardianship cases following a direct representation model as well, and currently have about 500 open minor guardianship cases, some of which have existed since our program's inception in 2020, and then most of which are relatively new. In total, we've represented children in 2,415 guardianship cases here in Clark County, which has included about 3,600 children following the direct representation model for our clients, which again, as Katie articulated, though it does take a slightly different form for children, is a client-directed model of representation where we place the voice of the child first and foremost. We maintain as normal of a client relationship as possible, as we can with them, and empower them that this decision relating to guardianship will affect their life much more than it'll affect their attorney's life. So we are generally appointed at the initial filing of a guardianship, but we've also represented children in other contexts, most commonly when a parent seeks to terminate a guardianship, when they seek visitation, when another adult comes to substitute in as guardian. And then often due to, one of the judges mentioned the ex parte communications that are allowed, that we call them Rule 5 communications, colloquially, where there's a suspicion that children are being abused by the guardian, and the child just needs someone to give them a voice, someone to talk to. And we've noticed in a lot of our cases, the caregiver who's now seeking guardianship has been caring for the child for some time, sometimes from infancy to 5 years old, and then it's time to enroll the kid in kindergarten, and they don't have a guardianship, so they come to the court, and that can prompt a lot of litigation, legal action, objections from parents. They may need to take the child to the doctor for a specialist. And then sometimes a parent is threatening, after leaving the child in place for 6 months, a year, 10 years, to pick up the child and remove them from the care of their caregiver they've lived with for most of their life. So we, to kind of focus our presentation, because I think when we started representing children in guardianship, our assumption was we were dealing primarily with orphans, and that is very much not the case. So we looked back at our data just from the last 6 months, so filings from January of 2024 through the end of May. And in only 7 of our cases were both parents deceased. So the remaining, so that's 3% of the total cases that were filed. So the remaining 97% of cases, there's at least one living parent. And then when we break those numbers down further, what we see is about 68% of those cases, I'm happy to go through each granular number, but I don't think anyone wants that. But in 68% of cases, we're dealing with safety issues that include lack of resources. So a parent or both parents are homeless, unemployed, unable to provide for their child's basic needs. Medical care, food, housing, education. A parent has just abandoned a child. So we have a number of children who, for example, have been kicked out of the home because of their sexual orientation. We have children who are being physically or sexually abused at home, and instead of going through the dependency system, the family has resolved the issue by just having a relative take over. We have a number of cases where there's ongoing domestic violence in the home, where the parents are engaged in sale of drugs. So it's often listed as a drug house in the petition by the petitioner. The parent may be engaging in prostitution in the home, or there's just other unsafe situations in the home. And then many of our cases relate to untreated mental health and untreated substance abuse. And so as we've kind of mentioned multiple times, there's a significant amount of overlap between the population served by 159A guardianship and 432B dependency. So both systems are primarily charged with keeping children physically safe. However, guardianship does not focus on kind of ongoing child safety as it relates to the possibility to reunify with a child. When it works properly, dependency will wrap a child and parent in services so that the child can receive the educational services, the therapeutic services, the medical services that they need in a safe environment, and the parent can work on reunification. None of that exists in guardianship. So most guardianship cases, unless something goes wrong or something else comes up, will have one hearing before someone seeks to terminate. It'll be the initial petition for guardianship, and then the guardianship will go on. And that works for the vast majority of cases. There's no such thing currently as permanent guardianship, but a lot of guardianships act as permanent guardianships. But by contrast, dependency has many hearings. They, I think, have at least one hearing every 6 months. There's no case plans in guardianship. There's no appointed attorneys for parents or for guardians, and the appointment of counsel for children is permissive. There's no requirement for visitation or guidance on step-up visitation in guardianship. There's no caseworker involved, so there's no one checking that the guardian is actually appropriate. And then on the support side, there is functionally no support for a guardian. So in Nevada currently, a guardian can petition or can seek child-only TANF, and they can receive, I believe it's $432 a month, regardless of how many children they're taking in. So one child or 9 is the most we've ever seen. They get $432 a month. In dependency, kin gap and adoption subsidies, I believe, are around $800 per child per month. And then that does not consider the fact that children who age out of dependency can also get OPLA. They can receive those same subsidies. And then, as I mentioned, there's no social workers, there's no caseworkers. And this lack of resources really does create safety risks for the children that we serve. We've had, just anecdotally, in the last month, we've had 2 guardianships terminate due to lack of resources, where the child has just entered the foster care system now because a family member can't afford to care for the child. Go to the next slide. So don't want to go through this too much because it was already covered in a prior presentation, but we would highlight that there's many changes from the 2017 reforms that were fantastic. The permissive appointment of counsel, the basic recognition that children who are in need of guardianship who don't have fit or suitable caregivers have different needs than incapacitated adults were fantastic. But from the representation of these thousands of children in Clark County, we've identified some kind of broad issues that we think are ripe for reform. So the first one that I'd like to discuss is the concept of emergency. So every child needs a grown-up to take care of them, right? Every child needs, every child, every baby to 17-year-old needs someone to make sure they get to school in the morning, that they go to the doctor, that they're fed, that they're safe. In minor guardianship as it currently operates, the mechanism for seeking if there's an emergency, is to seek a temporary guardianship. In practice, the procedural requirements of seeking a temporary guardianship, and I'll discuss this more on the next slide, are almost impossible for a petitioner to satisfy. And so what that means currently in Clark County is that our wait times to get in front of a judge for the initial petition are 3 to 4 months. And children's emergencies cannot wait 3 to 4 months. And even if there are emergencies such as this child can't get into school because there's no guardianship, 4 months of education, especially for a child who has experienced the trauma that led to the need for guardianship, is too long to wait. And then for the next bullet says age of 14, and what that's referencing is that under our statute, as it's currently interpreted, a child over the age of 14 must consent to a guardianship, but the consent or objection of a child under the age of 14 is irrelevant. How it actually reads in the statute is that the opinion of the child over the age of 14 only needs to be considered in the case of a competing petition. So if a parent comes to object to a guardianship, it's actually not required that the court consider the objection of the child over the age of 14, even if there are major safety issues. And that folds into the fact that, like any other matter relating to child welfare or custody, the court must consider the best interest of the child. These are children, as I've mentioned, who've experienced extreme trauma, often very young in age. And the statute correctly mandates that the court must always act in their best interest, but the statute doesn't define what best interest for this population of child means. So what we've observed is that judges often borrow from the custody factors, which are from NRS 125C, which compare two parents. So when it's considering best interest of a child, it asks, like, what is the level of conflict between the parents? What is the ability of the parents to cooperate? That doesn't apply in guardianship. So we have a large missing chunk of law that we need to make sure that these children are the primary focus of the process. Right now, the court does not need to consider the relationship beyond blood relationship. So within the factors that the court must consider, it has to rank when there's competing petitions, it has to consider a ranking of blood relations. It completely excludes the fact that many children in Clark County have significant relationships with godparents, with step-parents. They don't have any level of priority within the statute for consideration for placement. So just again, anecdotally, we had a competing petition that we saw earlier this year where mom, who was dying of cancer, wrote a will indicating that she wanted her best friend to take over care of her daughter when she died. And an uncle from out of state petitioned for guardianship, having never met the child, and the judge, essentially, they were more wealthy than the best friend. The judge granted the guardianship, which is contrary to what mom, who had then passed, had wanted for her daughter. So our hope from our experience is just to update the factors to really put the child front and center, both at the initial petition stage, the citation stage, and then when we move towards visitation and then potential termination, to make sure that the factors are appropriate to recognize the actual needs of the child and the family. And I just want to hit on one piece relating to termination. It is a little bit complicated, but I think that ties also into informed consent as well. So, and as I mentioned, it is extraordinarily rare in this system for a parent to have an attorney. There are no free attorneys. These are parents who are struggling. So what the statute currently reads is that when a parent consents to guardianship at its inception, so affirmatively consents, then when they want to end the guardianship, they have to show that they've corrected the reason for need for guardianship and they've been restored to suitability. So they fixed what the problem was, they can meet the needs of their child. If the parent did not consent, they also have to show that that terminating the guardianship would substantially enhance the well-being of the child. Now, anecdotally, in the 5 years that I've been doing this, I think I've seen 2 non-consent-based guardianships ever end. And this includes parents who weren't involved in the guardianship process, so they were held to this higher standard. So what our concern is both parents, but also guardians, don't know what they're getting into. Parents think that, it's completely reasonable. They think, oh, someone wants to take my kid away from me, I need to fight for that child. And our judges often do a good job explaining the consequences of that. But when they don't, and when a guardianship has existed for 5 to 10 years in the prior system, they don't know that they're not going to ever get their child back, that this is going to be a permanent situation. So again, we think that ensuring that everyone knows from the beginning that what a guardianship is, how it might terminate, what resources would be available. We heard that there's a class up in Washoe that sounds fantastic. What resources might be available down in Clark County would help everyone understand what the guardianship process is, really to keep these children safe and help the family. And I referenced this. So this just to highlight one major issue that we're having relating to temporary guardianship. So in the last year or so, we've we focus largely on the issue of denial of temporary guardianships. So it's a very complicated system to get temporary guardianships, but these are 3 cases where petitions represented major emergencies relating to the needs of the child. So the first one, the child was in need of medical treatment for kidney failure. The doctor had actually signed a note saying, yes, he needs this imaging so we can check if he's in kidney failure. Can't get it because there's no guardianship in place. Temporary guardianship was denied. We had to file a petition for writ of mandamus to the Nevada Supreme Court to get the petition granted. In the interim, this child was actually removed by the dependency system. Then we had 2 children, 10 and 14, whose mom was homeless and then had a history of domestic violence relationships. She was in a relationship with someone who'd been convicted of felony child abuse within that year and was attempting to get her children back. Grandma petitioned for temporary guardianship. It was denied. And why this causes such an issue in part is because, as I mentioned, we then have to wait 3 to 4 months to get in front of the judge at all. And then finally, the most recent petition for writ of mandamus we had to file related to a parent who's under legal 2000 hold. CPS had been involved, creating what's called a present danger plan, where a parent agrees to a temporary mechanism to keep the child safe with the CPS caseworker. But it expired. Mom came to come get her child without ever resolving any of the underlying issues. And again, that petition was denied.
And Jonathan Norman, for the record, we're ready for questions, but I do, just to put a final point on those slides, those 3 cases where we had a temporary guardianship that was denied, where we had a clear emergency, those kids were lucky enough to have an attorney who was practicing in this area for the last 5 years. We don't represent every kid in Clark County. We don't have the resources and the number of attorneys. So I think it's important when we think of how do these laws impact the pro se litigants, the unrepresented kids. And so while it's great for the 3 kids that we were able to help, I think, and all those kids had delay, right? That created uncertainty. But for the kids that don't have an attorney, I think it's really dire. So thank you, and we're ready for any questions.
Thank you for your presentation. Members, are there any questions? Vice Chair Scheibel?
Thank you. I wanted to go back to one of your slides about NRS 159A and 432B. And I think I missed an important kind of distinction at the very beginning of that section. And I apologize for making you repeat yourself, but could you kind of outline the difference between, is it 2 different types of guardianship cases?
This is Jonathan Norman, for the record. Yeah. So when in the Children's Attorneys Project, we have the 432B cases, which are actually dependency, abuse, and neglect, which does have a guardianship function within there. And the reason we draw them together is our minor guardianship team is nested within CAP because it is the same group of families that we see, the same issues bring them in. And we just wanted to contrast the supports that come with that 432B case. The parents get counsel, there are case plans, there's a visitation plan, and there's an idea that the kids might reunify, right? And there's a lot of court dates versus if a case is routed to a 159 guardianship, there's one hearing, often there's no counsel for the attorneys, and there's no support. And it's especially telling when you have, grandparents who are at poverty, who take on, they're afraid their grandkids will go into child welfare, so they take on all this responsibility and then end up disrupting because they're at that poverty line before taking on that responsibility.
And am I understanding correctly then that 159A generally would not have CPS or DCFS involvement, whereas a 432B would?
So, Jonathan Norman, for the record. So it's ongoing CPS involvement. 432B cases are the Department of Family Services. It's intimately involved in every process. What I will say is the 159 cases often have had CPS or DFS involvement at some place, and maybe right before that guardianship paperwork was filed.
So like a 159A case might be like my neighbor's kid comes and stays with me. There's obviously stuff going on at the house. And then at some point I decide that I am willing and able to take responsibility for this kid. I file with the court to become that kid's guardian. And then their parent has to either, like you said, consent to it or not consent to it. And that would be like the 159 case. And so I think, I see that you're nodding. So now I think what I'm understanding you were saying was that oftentimes in those situations, the circumstances aren't actually that different from a 432B case, because what you have is that neighbor, that cousin, that grandparent who steps up before DCFS actually opens the file or after they've not substantiated the allegations or something like that. But we're not talking about like incredibly sophisticated families where one person is taking over guardianship and everything else is copacetic and everything's cool. And then we just need this paperwork because the kid is going to live with me instead of with their biological mom and dad. Like these families are generally struggling, and that's why the kid has to go somewhere else.
Yeah, Jonathan Norman for the record. That's exactly right. And it can be it can be CPS has responded at your neighbor's home and you're there and you say, I have a good relationship, and they create and you're going to go file guardianship so the CPS case is averted. Sometimes that's not appropriate, right? And sometimes it is, depending on what the parents understand that guardianship means. Because in that two-tiered system, if that parent fights for their child in that guardianship, it functions as a termination of parental rights. So it's significant, and it's significant that they don't have attorneys so that they, both the neighbor, right, you understanding I'm not going to get any resources and support, and those parents understanding the gravity of that moment. So I think, the importance of having counsel for those decisions is really vital.
Thank you for clarifying.
Any additional questions? All right. Not seeing any, I will go ahead and close this agenda item. Thank you so much for your presentation. Our next agenda item is agenda item 7, which is a presentation on the services provided by public guardians. From Douglas County, we have Nicole Thomas, public guardian. She is present in Carson, I believe. And then here in Clark County, we have Karen Kelly, also a public guardian.
Good morning, Chair Miller and committee members. My name is Nicole Thomas, Nicole Thomas, Thomas. Thank you for allowing me to speak today. I'm the Douglas County Public Guardian, and I have served as a public guardian in Douglas County for 9 years. I have over 15 years of experience in the social service industry, including but not limited to substance abuse, mental health, children's mental health, wraparound case management, and of course, guardianship and elder affairs. I have a bachelor's in political science with a minor in psychology, addiction studies, a master's in elementary education focused on developmental disabilities, and a master's of science in professional counseling focusing on family dynamics. I'm a national certified guardian as well as an ethics and compliance trainer through ECI. Public guardianship is a crucial part of the robust social services model. Public guardians partner with families, service providers, law enforcement to promote safety, well-being, and a least restrictive environment for clients. What I need the public to understand is that capacity to make and communicate decisions is very different than capacity in other contexts, such as criminal matters. And guardianship is a mechanism to navigate and secure services, but we cannot create resources where none exist. The focus of the statewide the statewide guardianship commission membership has been for Washoe and Clark counties and has avoided some of the rural difficulties. The Public Guardian Office visits clients for their care, and in Douglas County last year we served 156 grocery deliveries, 192 doctor appointments. We served 20 indigent clients out of our caseload. We had 4,129 direct client service hours, and we traveled 5,283 miles in the service of our clients. Public guardians in the larger counties utilize institutional placements, while rural public guardians have a greater proportion of clients in home whenever possible. Over a quarter of my caseload typically live in home. The average private care cost for elder care is $6,000 to $11,000 per month, whereas the average income for an elderly person is less than $2,500. 33% of Douglas County residents are elderly, and 7% additionally are disabled. This does not include the calculations for mental health populations, which are numerous. This population are not well suited for the cooperation with services required by guardianship. However, our office serves all clients with mental incapacity in our area. Douglas County has one Medicaid skilled nursing facility. All clients needing Medicaid services outside of this skilled need must be placed in other counties, and that means 71% of our clients are placed out of our county. And that's longer drives for our staff members in order to serve them and meet our monthly needs of visitation. The average worked hours per month for the public guardian in Douglas County is 281, and this does not include vacation or leave, training, education, or administrative time. My deputy PG averages about 273 hours, and our accounting specialist about 253. I'd like to remind the commission that a regular 40-hour work week per month is about 160 hours. We accomplish all of this with 3 positions. We are responsible, I specifically, for the educational, administrative, legislative, budgetary, and oversight of the department and the guardianship for our county, in addition to carrying a full caseload. Those 3 positions are the public guardian, myself. I have 1 deputy and 1 accounting specialist. The average caseload of the PG in Douglas County is 25 to 58 clients with varying medical, financial, and personal needs. This includes guardianship of the person and the estate, small probate cases, and trustee services. The public guardian is an on-call and accessible 24 hours a day, 7 days a week, 365 days a year. The Douglas County Public Guardian has been preparing to open a brand new represented payee program, partially funded through the grant via Aging and Disability Services Division, to allow clients to remain in their homes in their community for longer periods of time so that we can keep them in our county. Rural county public guardians have challenges related to where they fit within the county structure. For the last 9 years, I've been overseen by the county manager, but just recently, I was moved to the Community Services Department. And tensions between NRS 253, for example, and county rules for Douglas County Code 2.22030 are quite difficult to navigate within my county. A large portion of what my office does is investigation. 80% of my caseload are financial exploitation and neglect cases, and these cases are difficult cases that are investigation and resource heavy. In cases that are having a difficult time getting to guardianship or have been lingering in the community as a repetitive resource user, our investigation NRS, SB 121-2019, allows us to get guardianship or facilitate a family member stepping in. The path to guardianship is difficult for families who understand, afford, and complete. Legal aid resources are often conflicted out because they represent the proposed protected person, and the process can be very stressful for loved ones. We have significant limited resources in the rural areas, and this has led to placement for clients in the most restrictive means, including jail and mental health facilities, and sadly, it's led to death. Our office is usually getting cases at the end of life in the most dire of needs. These fragmented relationships in the rural areas lead to disconnection of wrong door policies, and they've led to clients floating within the system, and decision-making capacity being determined by system partners instead of medical professionals because it's so difficult to get evaluations completed. There are no private professional guardians in these areas to offset the limited resources of the public guardian. Limits to funding or support for the public guardian, while demands on the office are serious and frequent. The medical and financial needs of the aging population are increasing while there is no funding, support, or additional staff offered to maintain quality service and meet community needs. There is excessive burnout through the entire system. Concern over passing cases to the public administrators and counties over concerns of the cases will sit for years. This increases caseload for final accounting activities where a client has passed away as a result. We have nowhere to send families seeking support to file guardianships. That places the burden on the public guardian's office and should not be giving legal advice. We lack the resources to spend time helping fill out guardianship paperwork. We're making some policy recommendations. Specifically in the rural areas, we need funding for public guardians. We have continued to take on the brunt of changes in guardianship and the changes in workload with no changes in supports. We need resources in the rural areas and access to lower levels of care so that we can have those lower levels of care in the rural areas. We, as a PG, do not need to be the answer to every problem. We need Medicaid-funded facilities. We have no housing and no support for mental health. Limited and full Medicaid-funded housing. All of our Medicaid facilities in Northern Nevada are pretty much full. We need courts to understand that the lack of resources are placing unrealistic demands that cannot be attained on the public guardian with limited options. The Guardianship Compliance Office either needs to be accessible for the public guardian's office outside of a court order mechanism, or needs to be an independent office not under the judiciary so that it can be utilized by other entities and not conflicted in supervision. Most of Nevada is rural. Most of our counties are rural. The current policies in place do not provide for our rural areas. We are required to meet the same level of needs with little to no support. We do not have access to the same supports that urban areas do. Each county is different, and county management need to be held accountable for the caseload and the consideration of the public guardian department. Oversight of the department should fall within the jurisdiction of the Board of County Commissioners as it is stated in NRS and not subsumed by other departments. This causes extreme conflicts of interest. Due to the difference, some counties do not receive any support. The rural public guardians are expected to meet the same needs without the same staffing, the same internal and external supports, and the rules of engagement. Some counties have public guardians doing multiple roles without full legal support, and due to the funding structures, these conflicts of interest are overlooked as a cost-cutting measure. A state public guardian's office could be created and leveraged in order to help monitor and manage challenges to Nevada. There are significant conflicts with the public administrators. Appointment of oversight of the public administrators will reduce caseload of the public guardians who are accountable for clients' estates when they pass, and whom those estates will pass to for final distribution. Perhaps move to an appointed model for public administrator roles and not an elected role to attract well-trained and diligent individuals who can be held accountable to supervisors of their county. And in the last 6 years, this turmoil in many counties with the public administrators have caused extreme caseload increases to the public guardian in the rural areas. Currently, Nevada does not allow individuals who are guardians to be compensated for providing Medicaid cover services. Families must choose between being able to be paid or offer to be a legal guardian. Other states do allow these guardians to be compensated for service provision, and this would be helpful to alleviate the public guardian caseload in the rules. We also need to have a place to send families to work within the difficult guardianship systems. Families will need legal advice and case management and social work support. This task has fallen to the public guardian's office that have no resources, time, or ability to meet this task. The documents and processes are different for even master-level clinicians and social workers and are difficult to understand. When families and friends do not file for guardianship authority, individuals in need float in the system for long periods of time, and the individuals are often exploited and have resources depleted until the case reaches the public guardian's office. Those cases are extremely time-consuming. I'm available for questions and below specifically for independent cases.
Thank you for that. We're going to go ahead and continue with the presentation and then ask questions at the end, okay?
That is the end of my presentation.
Right, but for this is at the end of this agenda item.
Thank you.
Okay.
To begin, my name is Karen Kelly. I am the Clark County Public Guardian. And I just want to thank you, Chair Miller, for allowing me to be here today and to the rest of the committee. So thank you. I'll hopefully get my PowerPoint up here shortly, but I'll just begin by just briefly talking about guardianship and kind of what we do as a public guardian. Firstly, we assist individuals who have been deemed incompetent by the court with their medical and financial needs. But most importantly for that, there must be a showing that there's really no friends or family willing or able to serve as their guardian. We really, as a public guardian, should be seen as the last resort. At the Clark County Public Guardian's Office, we don't accept direct referrals. Under NRS 253.220, we can only start to investigate the medical and financial affairs once we've been appointed. In some of the rural areas, there's a different mechanism in counties that have under 100,000 to investigate beforehand. But in Clark County and in Washoe, we can't even start to look into that case until we have been appointed, which means we never have information to file our own petitions. So all petitions are filed by a third party. So that third party files the petition, notices us, lets us know what's going on. We show up at that hearing. If they show by clear and convincing evidence that a guardianship is needed and that there are no other friends or family willing or able to serve, the court will appoint us as the guardian. The majority of our referrals here in Southern Nevada come from hospitals and skilled nursing facilities. Then aging and disability services, we get them from adult protective services. We get referrals, the petitions filed from Southern Nevada Adult Mental Health and from Desert Regional Center. Then the DA's office, the Clark County DA's office, will file petitions for our services for children with disabilities or are aging out of the child welfare system and maybe have no family able to serve as that guardian. And then the court, in situations where there's concerns, will appoint us, and legal aid attorneys have often asked through petition for our services in some cases. And finally, family members do file petitions requesting public guardian to become the guardian for their family members. After we have an appointment, we actually have intake case managers that solely work on these types of these new cases. They'll search for and marshal all the assets, including all income sources, bank accounts, investment accounts, life insurance policies, anything you can think that you would have, we're trying to find. They'll meet with the protected person, obtain level of care recommendations from medical professionals, and determine what current medical needs they have, review necessary preventative care, and we really want to discuss the protected person's goals regarding their medical and end-of-life decisions, which of course is always difficult, and what they want, what their goals are for placement. We obviously try to meet these goals, but in some cases, we're not able to, and that's when we'll work with their attorneys to try and come up with some of these compromises. The office is divided here in Clark County into two kind of sections for my case managers. We have a person-centered side and a financial side. So every case we're appointed on, they have two case managers that work on that case. The person side goes out and visits with the person monthly, make sure all their care is taken care of, and really focus on all the medical stuff going on. The financial side will get all benefits, apply for whatever needs to be applied for, Medicaid, Social Security, and really focus on that side. So we've got some really good competency levels of people who are able to focus very specifically on certain parts of a guardianship. We also have a representative payee program in place. We have that partially of a grant from Aging and Disability Services, and Clark County does supplement that. We only have one case manager who works that caseload, and it has about 90 cases right now, and we have about 15 on a wait list. But this is a voluntary program. This is not where a guardianship has been imposed. This is a voluntary program that assists with allowing people to stay in their own homes or their community, their apartment, their whatever level they're in the community, when they may be struggling to pay their bills, they may be a victim of exploitation, they could be at risk of eviction. These are the types of people that will come to us for us to start managing their money. Currently, the representative payee program we have is for 60 years and older. Just to give you a little idea of our current caseloads, we kind of went back to 2016. I became the public guardian in Clark County in 2016. And at that time, we had a caseload of about 369 cases. As you can see, through the end of last month, we're now up to 862, which we've over doubled our caseload in the past 8 years. And there are a couple of reasons for that. We changed the way we used to accept direct referrals before 2017. And in 2017, we changed that model in line with the statutes. And now we have the third-party petitions. And that has really allowed people to come to us when we're needed. It's also, I think, a mechanism of there's just one private professional guardian here in Southern Nevada. Before the reforms in 2017, and even a couple of years after, there was at least 3 additional, so at least 4 that I remember of private professional guardians, and they have slowly just disappeared, which has led to more cases being taken on by the public guardian. Just a little bit of an idea of what our housing is for our clients we serve. Over 83% of the clients we serve are currently in nursing homes or group homes. We have a few in assisted living, of course, in the hospitals, and a few in independent living. But for the majority, we're looking at nursing homes and group homes. I won't go over too much of the reforms. You kind of understand where we were as a state before the reforms, often people getting into guardianships without their knowledge, the least restrictive alternatives not being explored, and really guardians making a lot of decisions without this kind of person-centered approach and having everybody involved in these decisions. I will say, in my opinion, the most important change was that legal counsel has been given to the protected persons when those petitions are filed. And when I go and speak in other jurisdictions about reforms and things that have changed here, this is the one change that's most discussed. And quite honestly, a lot of people really fear it. I'll have people ask me, well, as a guardian, are you just in court all the time, fighting out every decision you want to make? And I let them know we're not. We've developed a very good working relationship with the Legal Aid Center, and we first try to work things out over emails, phones, going to see them in meetings before we even go to court. And we're really quite successful of making sure these issues can be taken care of outside of the court environment, but everybody is still involved. I'll also say, of course, there are times we have to go to court, and even sometimes very quickly we need to get in, and the court has been very accommodating in getting us into court to be able to rule on some of these decisions. Okay. Sorry. The other thing I will say about legal aid attorneys and having attorneys for the protected persons from when the petition is filed, that they are quite successful in arguing against a petition for the guardianship and really advocating for less restrictive alternatives to that guardianship. For the Public Guardian's Office in Clark County, in 2023, we received 254 petitions requesting our appointment as guardian. And we were appointed on 199 of those cases, which is an appointment rate of about 78%. Of the ones we weren't appointed, some of them, unfortunately, had passed away. However, for a majority of those 22 cases we were not appointed on, the Legal Aid Center had successfully argued against a guardianship, and the petition was just dismissed, or they found another alternative to guardianship, or an alternative to the public guardian serving. Those numbers hold true back to 2022, when the appointment rate was about 77%, and in 2021, it was about 76%. I will say the highlight of all the reforms has been the person-centered approach, which is definitely a huge benefit to anybody under guardianship. So real quick, a couple of our current struggles we have here at the Public Guardian's Office. As anybody will tell you, in Southern Nevada, mental health is it's somewhat a crisis. But our placements for clients with serious mental health diagnosis, there just isn't any. Our clients with these serious mental health diagnoses just cycle through various hospitals and nursing facilities in the Valley until nobody wants to take them anymore because they've gone through every nursing home we possibly have. And then we must find placement outside of the Las Vegas area. Many of our some of our other mental health clients who don't really have the serious mental health diagnosis, but have just a kind of a middle of the road, I guess you could say, mental health diagnosis, we've been very successful in placing them under the Medicaid behaviorally complex care program that Medicaid has for the nursing facilities. This is a tiered reimbursement program that pays extra funds to nursing homes to provide additional care for mental health clients. But for our really challenging to place clients with serious mental health, this kind of program doesn't even work. The nursing facilities do not want to accept these individuals. I'll tell you about right now, I have about 30 individuals that could really benefit from homes in the community that provide intensive case management. I will tell you, of these 30 people we have, they probably take up the most of my case managers' times. My working definition of what intensive case management means is monitoring and evaluating individuals with serious mental illness on a continuous basis to determine if additional services are required while providing crisis intervention, skills building, and advocacy. And really, as part of that is this mandated caregiver training that we really want to put forward as a possibility. One of the problems is there is currently a small pilot program of a group home here in Southern Nevada for serious mental health. And I have a couple of individuals that are in that home. And what we have found is even though additional funds are being paid to that home, the caregivers are not specifically trained on mental health. And they're not trained on caregiver burnout and identifying that. We've seen a lot of this caregiver burnout leading to abuse and neglect of individuals in group homes. And that's why I feel that mandated training, if we're able to get a serious mental health group home in place, is going to be absolutely necessary. I've been very lucky that this year I've received some funding in working with Clark County Social Services to try and open our own home, or at least find a provider here in Southern Nevada that we can find some beds for these clients with serious mental illness. My goal over this next year, once we get this open, is to track the hospitalizations over the past few years and show that with this intensive case management, the mandated caregiver training, that we can reduce the amount of hospitalizations, and hopefully the cost savings are going to outweigh how much we're paying. These intensive case management homes are expensive, but I feel that the cost savings, we're going to be able to show it. It's not only the ER visits and the subsequent psychiatric care in psychiatric hospitals. There are extended hospital stays of months and months where people sit in the hospital because nobody will accept them. It's the police call-outs, the paramedics, the ambulance costs. And sometimes these individuals, unfortunately, end up in the criminal justice system. So the jail time, the cost for that, the court time, the prosecutors. And for some of these cases, we could be looking at this 8, 9 times a year, just cycling every few months. So I'm really hoping, like I said, with this county-funded home over the next year, we can bring back to you and show you some growth or some way for us to get these type of homes. The other part to mention is that it's not just the financial cost, it's the human cost that's not really quantifiable. Of these individuals spending so much time in a hospital or a jail setting and not getting to experience life, all because of inadequate placement opportunities. These extended hospital stays that we're seeing, they're kind of twofold. They start from when we get involved as the guardian. We have no information on them. We get this case and then we start investigating. And it takes us a long time to get to Social Security, to get access to the banks. There is a lot of red tape, even as a guardian now, to get access to a bank account. And especially now that you've got these cards where everybody has the Direct Express, the PNC banks, where there's no bricks and mortar building to go to. Everything's done by snail mail because they want raised seals. Everything just takes a long time. And this is one of the reasons we see extended hospital stays when trying to get onto Medicaid. It's not Medicaid not working the cases, it's trying to get the information to them so that they can make a determination on the types of Medicaid. And then again, with regard to our individuals who are challenging to place, they often sit in the hospitals for long periods. Historically, when I first started with the Public Guardian's Office back in 2008, facilities around the Valley would accept what we consider pending Medicaid clients, where we're working on getting, and that has just stopped completely here in Southern Nevada. So just a couple of policy recommendations. I feel, as you've heard other people talk about, the less restrictive alternatives to guardianship are so important. And while we have the language to have these things, sometimes I think we don't specifically ask the petitioner who's trying to get the guardianship what they have actually done. I think the petition has a few boxes that say, have you considered or tried these less restrictive alternatives? But we don't really ask them, what have you done for those restricted alternatives? Or why do you think they won't work in this situation? So I think having the petitioner actually document the reasons why these less restrictive options have not or could not work is going to be important, because we have the tools for the less restrictive. We just really need to ensure the petitioners are using them beforehand. I will say sometimes it seems the easiest option for the petitioner is a guardianship so that they can discharge an individual from their facility. However, we keep educating that guardianship really should be the last resort. Another thing to consider is when we're looking at the powers of attorney and all of those different things, is having them available in other languages so that people who may have that language barrier still have the opportunity to put these less restrictive alternatives to guardianship in place before a petition is filed. I do feel that reviewing the private professional guardianship guidelines is something I will be bringing up with the commission. Private professional guardians are really an integral part of a healthy guardianship community. It allows choices for individuals, and it can take the strain off of families and ultimately the public guardian. And as previously discussed, we only have one private professional guardian currently practicing down here in Southern Nevada. And finally, just briefly, I want to just talk about the 1915I programs. And while I realize these are Medicaid, and I'm not a Medicaid expert, as a consumer of these programs, I really feel like they're such great programs if they could be expanded. So a 1915 waiver program is a home and community-based service waiver that are designed to allow states to provide home and community-based services to people who actually need long-term care, but they can stay in their homes or their community setting, their supported living, assisted living, group home, instead of ending up in a nursing facility. The 1915I program here that I know about down here in Southern Nevada is fantastic. It is a Medicaid program that's been around for a few years. That is a great resource for our brain injury clients. It's very specific for a brain injury client. The providers are wonderful, and we've had so much success with this relatively new program. But it'd be great if this could be expanded just a little bit. And I don't mean expanding the definition of what a brain injury is, but there's some Medicaid issues within it that the codes are too narrow. And I'm hoping that we can expand that definition. I had a lady who was flourishing in the 1915I program, and because we got her additional benefits through Social Security and then her Medicare kicked in, she was no longer eligible for this program. I had to move her out of that home, and she actually decompensated to the point she's back in the hospital because the type of Medicaid she has flipped and it wasn't available on this program. And then finally, if we could expand all the waiver programs for mental health group homes. It just allows Medicaid to pay for some of these mental health group homes because when you're on the SSI of $943 a month, finding a group home that's going to do your medications, cook for you, do all the things that you might need is incredibly difficult. So thank you very much for your time.
Thank you so much. Members, do we have any questions? Senator Scheibel?
Thank you. I have a question for both public guardians because you both mentioned that there's one in Southern Nevada and no private professional guardians in the rest of Nevada. And I'm wondering if you can describe a little bit what that role looks like and whether it's common in other places.
Nicole Thomas, Douglas County Public
Karen-
Guardian, for the record. The changes in law in 2017 made it extremely difficult for private professional guardians to stay in business. And that has been the reason why it has, they have gone away. So in the north, we've had them in and out of the system, but if you are going to care for more than 2 protected persons in the state of Nevada, you need to be licensed. And it is very difficult in order to, through the court mechanisms, in order to pay for that care. So that is the reason why in Northern Nevada we are struggling so difficulty. The private professional guardian steps in when a client has extensive funds and has the ability to pay for a private guardian and gives them options other than the public guardian. When I first started in 2016 as the public guardian, we maintained only clients who had very limited funds, which makes it easier to do our job because the decisions are less complicated for placement. Now we manage millions of dollars in funds, which makes our job more difficult.
And to follow up and kind of clarify, so I guess I'm lucky I've never had to hire a private professional guardian or work with a private professional guardian. Is that something that somebody would do as their, sole professional function, or is it something that, is offered by a law firm or by a social worker? Who would serve as a professional public or professional private guardian, or do you go to school for it?
Nicole Thomas, Douglas County Public Guardian. There's not really a program for it that you would go to school. Typically, financial institutions have created guardianship, but they are no different. Private professional guardians are no different than your public guardian and your family guardian. We're making all the same decisions. The difference is that you typically do not handle indigent cases, and they are referred separately. Actually, I don't know how the referral system would even work these days. In our county, what we would do is if we find a client who does not have a family member to serve and a private professional guardian was appropriate for the situation, we would then refer that client over to the private professional guardian so that they could spend down their resources and eventually come back to the public guardian. But as far as I know, there's not a course curriculum for that.
And this is Karen Kelly for the record. I know down here the one person that does it, she has her own business, she is the sole business is her guardianship business. And there was at least 2 or 3 others that had it as their sole business. So yes, that's how I think they would do it. I know here some of the hospitals will refer to the private guardian for some of their cases if they want, if there's certain things that they need on that. As far as I do know I've had people who they do have this kind of negative feeling about being as under the state. Like I have some of our clients like, I don't want to be a client of the state. I'd rather have someone else help me. And it's just about choice, I think. But that's the other area that people have seen as family members have been more comfortable with a private professional in some instances.
Any other questions? Okay, not seeing any. I will go ahead and close this agenda item. Thank you so much for your presentation. Thank you. So here's what we're doing with our next items. We are going to switch agenda item 8 with agenda item 13. So that means that we will hear agenda item 13 right now. I believe we have some actual, our actual active duty dogs are with them. And so therefore we want to make sure we're accommodating them. And then agenda item 8 will be last today. Depending on how long this item goes, we'll see when we will break for lunch, but we will at least hear agenda item 8 right now. And so that will be a presentation on the activities. Oh, that is not, I just said we're switching. What we're going to hear is presentation on the use of facility dogs in the criminal justice process and recommendations for legislation. We have Michael Browett, who is a lieutenant and the facility dog handler for Community Services Division Parole Section with the Reno Policy Department, or is that Reno Police Department? We have a typo. That's Reno Police Department, right?
Yes.
Okay, and joining you, I believe, is the dog Winter. Is Winter the only one with you, or do you have another one besides Winter?
No, also here in the room with us is Tofi with Carson City Department of Juvenile Justice.
Where's Toki? We don't see Toki. Where's Winter?
Winter's underneath the desk right here. Let's see if I can get him on camera.
Okay, well, there's chairs if Winter needs a chair. See, that's what we've been waiting for. So, and where's Toki?
She's going to
Toki
walk
not
on
coming?
here. She's right here.
She's not part of the presentation?
You got to walk closer to the. There she is.
Oh, okay. All right, so now you may, whenever you're ready, you may all begin your presentation. Thank you.
Thank you, Chair Miller and the rest of the committee. I'm honored to be here today to speak on this topic. And a great segue, obviously this morning we heard a lot about adults and children and the vulnerabilities that they face, especially dealing with trauma. And that's some of what I want to discuss today, is how dogs like these can be used in the criminal justice system, particularly in courtrooms to support vulnerable victims. So just a little bit of background again for the record. My name is Michael Browett, B-R-O-W-E-T-T. I'm currently employed by the Reno Police Department. I'm a lieutenant assigned to the patrol division right now, but I am the fortunate handler of our facility dog, Winter. And just a little bit of history on how Winter came to be. In 2020, I approached then Chief Soto about starting a program using dogs to help support not only victims of crime, but also employees dealing with the stressors that we face in law enforcement. So identified an organization that's a national organization called Canine Companions, who trains and places service dogs nationwide. And together we kind of spearheaded what we think, and I could be wrong, so anyone that knows otherwise, please feel free to correct me, the first inaugural facility dog program within Nevada's criminal justice system. Winter, again, she was actually born in 2020. I'm sorry, I got a typo in there. She's a purpose-bred Labrador Golden Retriever, and she's 4 years old now. And then I also am the Nevada State Coordinator for the Justice Facility Dogs U.S. organization, which is a sub-organization of an organization called Courthouse Dogs Foundation. And they are kind of the international leading organization on this topic. So since Winter's arrival, she has literally met and engaged with thousands of citizens of all ages, as well as employees in and around the city of Reno. She's provided support to hundreds of victims at various stages in the criminal justice system. And really significantly, and for me as a law enforcement officer, she's really elevated or helped to elevate the image of the Reno Police Department by breaking down barriers. It is amazing how many people come up and talk to me simply because of Winter. It kind of softens the presence of law enforcement, I suppose. And it leads to incredible conversations and community interactions with her kind of being the ambassador of that. One area, Winter works in numerous areas, but one area, and the reason I'm here today, is to discuss the use of facility dogs actually in a courtroom, in a criminal hearing, to support victims while they're testifying, in particular vulnerable victims and child victims. And that's something that we haven't been able to do because there's just certainly some legal complexities to doing that, which I'll get into. So it's important to define what a criminal justice facility dog is. There's an organization called Assistance Dogs International They're a worldwide consortium of service dog training organizations that set international standards for service animals in all areas, whether it be seeing eye dogs, hearing dogs, PTSD dogs, medical alert dogs, or in this case, facility dogs. There's hundreds of organizations across the country that are accredited. Some of the bigger ones and names you might recognize are organizations like Canine Companions, Guide Dogs for the Blind, Assistance Dogs for the West, Duo, but there are literally hundreds of ADI organizations. They provide a definition of a courthouse facility dog, and a couple things I want to point out with that definition is that they are placed in a criminal justice setting, the dog is. Their handlers are professionals in the criminal justice system. So whether that be a victim advocate, a prosecutor, a DA's investigator, a police officer such as myself, they are somehow a professional within the criminal justice system that's been vetted, as we all normally are. We understand the rules of the system. And we've also been properly vetted to make sure that we're not any kind of security risk when dealing with individuals, particularly children and vulnerable adults. So one thing that their definition points out as well is that the whole point is to have a dog that can work in a courtroom setting without creating any type of public nuisance. And so for that reason, their dogs, if they're going to be called a justice facility dog, have to go through the same public access test that any service dog would, and that is important. That's a very lengthy definition. You'll see in a little bit that through legislation in other states, a much more generic definition has been developed that simply calls attention to a facility dog being a graduate of an assistance dog organization that is a member of either Assistance Dogs International or a similarly recognized organization. So obviously we wouldn't want to limit it to just one organization, but it does call attention to the standards that they have. And this is an exact quote out of Idaho's state law as to how they define it. So some things a facility dog is not, and I want to preface this with dogs are amazing in my opinion, and I know I'm a little biased, but there are a variety of different dogs with a variety of different training. It's important when we're talking about an in-courtroom use of a dog within the criminal justice system, and particularly in a criminal case, that we know exactly what we're getting. So a facility dog is not a therapy dog. If you look at the different standards and the level of training, they're completely different. There are really no standards for vetting a handler of a therapy dog, whereas, again, drawing back to the definition, there are for a facility dog. Also, with therapy dogs, their work periods are typically shorter, whereas like Winter has been here since 9 o'clock this morning, and I don't think anybody's known she was here. So it is a different level of standard. And then one of the most important things, especially if we're talking about in courtroom use, is that most therapy dog handlers have to maintain control of the animal's leash, whereas with a facility dog, you do not. The dog can be away from the handler, the leash can be held by someone in the stand, and that's acceptable, and that has to do with somewhat with insurance and stuff like that, but obviously it's impractical to have a handler sitting right next to, or certainly not desirable to have a handler sitting right next to a witness while they are testifying in court. So the support and research, the use of these dogs in the criminal justice system is not new. It began as far back as 2008. In the references, you'll find a lot of very good scholarly articles, resolutions from different associations or organizations, as well as several laws. I just want to touch on a few things briefly. A very guiding document, the 2018 work done by Elizabeth Spruan, kind of compares facility dogs and therapy dogs and why facility dogs are the choice for in-courtroom use. And again, she highlights some of the stuff that I've already discussed. Another important guiding document is in 2021, the American Bar Association passed Resolution 101A. And it's a very good document. It very well lays out the reasoning behind the use of these dogs. But for today, I'd like to call attention to the fact that it really challenges and urges federal, state, and local territories to adopt laws and procedures to use these dogs in courtrooms. The Association of Prosecuting Attorneys in 2018 also had a similar statement, basically supporting the use of facility dogs. Same with the National District Attorneys Association in 2018. And in all of those documents, you will see that they draw attention to the specific definition of facility dog and kind of define it. Moving on, there was a bill at the federal level that unfortunately did not get past the House, was passed in the Senate back in 2019, referred to as the Courthouse Dog Act. And that act would have, if it had passed in the House, would effectively have laid out these same rules that I'd like to see laid out in Nevada at the federal level. And then the rest of the things, articles here that I reference, are really just more academic support for the use of these dogs in a courtroom setting. One of the biggest things, the last one you see, the concerns regarding the utilization of basically pet therapy dogs and their owners for witness support. And then there's sorry, got a little lost there. I don't have it quoted here, and I'm quoting the wrong one. But there is an article that I included. One of the biggest things that gets challenged is that these dogs can bias a jury in the courtroom. And there's actually a study in my material that talks about how the use of these dogs in a courtroom is actually less biasing than the use of a teddy bear that a witness might hold. So that's an important one to look at. So why now? Again, I mentioned earlier, the facility dogs have been in use across the United States since 2008. Right now, especially within law enforcement, but in criminal justice in general, you're seeing a big push to incorporate dogs into this type of work. What I'm seeing is that a lot of people are just getting a large variety of different types of dogs and bringing them into this practice, ignoring all of the best practices that have already been established through a lot of work and research since 2008. I believe that the long-term effectiveness of dogs like these in a courtroom setting in the state of Nevada is highly dependent on establishing best practices and having those codified in our laws. And then the last thing, timing-wise, is I'm seeing in Washoe County with the work that I do with victims, is we've had to say no to victims who have requested that Winter accompany them on the stand. And furthermore, we really can't get a good measure of how much a resource like this would be utilized, because it wouldn't be fair to query a child about, well, would this be helpful, and then tell them that they can't have that resource. So that's kind of the need and timing side of it right now. Just a brief overview of the use in the Ninth Circuit. I limited that. These dogs are in use in almost every state across the country. I think 41 states as of 2023. I chose to only narrow in on the states that are within the Ninth Circuit for our purposes, because that would kind of be the case law area that we're dealing with, should it ever be appealed to a federal level beyond the state. And you can see the numbers there. I won't go into them in super detail, but a couple things that I do want to point out is that in several states, there have been appellate level challenges to the use of these dogs, and in every instance, the use of the dog has been upheld. So there is not an instance that I'm aware of in the United States where the use of one of these dogs properly applied and the proper dog has not been upheld by the judicial system and judges and courts. So again, that kind of underscores the importance of it. You can see that Arizona has appellate law, California has a law and appellate law, Idaho has a law and appellate law, and then Washington also has a law and appellate law. So there's not much to what we'd be seeking. The first and foremost would be to define what a facility dog is. Hopefully the definitions I gave in the beginning have given some insight into what that is. Though I'm not an attorney, I have scoured the NRS, and there seems to be quite a bit of different definitions of vulnerable adults, child witness, for instance, but nothing that I can find that quite hits the mark. So I think a statute involving this would need to specifically define, for the purposes of the use of a facility dog, what a vulnerable witness or child witness consists of. And I think in most states you see that that's someone under the age of 18 or someone who would be considered a vulnerable adult by our definitions in state law. And then most importantly, add the authority for judges to authorize the use of dogs like this in a courtroom. And I believe the state of Idaho's law provides the best roadmap for this. Their law basically makes it a presumption that the dog shall be allowed in the courtroom unless the court finds that the defendant's constitutional right to a fair trial would be unduly prejudiced. And so essentially what writing it that way does is puts the onus on the defense to argue why the dog shouldn't be allowed to accompany a witness on the stand. And then lastly, in some way, shape, or form, adding facility dog to our definition of service animal within the state of Nevada, so that when the dog is acting in that capacity, when it's actually serving a client in the capacity of facility dog, whether it be in court or a pretrial meeting, that they have the same public access that service dogs have under the ADA. And that is really what I have. There's a couple of QR codes here, and to the references, again, several lengthy articles, all the different state laws can be referenced there. But I hope we can move forward with something like this, and I think it will greatly benefit victims in Nevada. I think one of my coworkers, who's a sex crimes detective for the Reno Police Department, said it best in talking about Winter and the work that he's seen her do with some of the victims, is that regardless of the outcome of the criminal case, if we can make the outcome for a victim, particularly children, if we can make that long-term outcome in their life better by reducing the trauma of not only maybe the experience, but also certainly the trauma of the criminal justice system in and of itself as a victim like that goes through the prosecutorial process, then we've done well. Because the goal, regardless of the criminal conviction, is to set that person on a trajectory where they're going to be able to recover from that trauma most effectively. And any resource we can offer to make that happen, I think we should seriously consider. So I certainly appreciate your time, and if there's any questions, I'd be more than happy to try to answer them.
Thank you so much, Lieutenant. Members, do we have any questions? I actually do have one, and I appreciate the distinction between the facility dog and the trainee support dog or therapy dog, because I think in my mind, I just believe they were all the same. But as you're talking about that there's not really a formalized training or procedure for either the handler or the dog, can you describe then how is the dog selected? What is it based on? And how is a handler selected? And I know we're speaking of only one dog but if you could describe what's currently happening.
Sorry, so kind of two parts to that question. Let me cover first therapy dog. There are several organizations out there, such as the American Kennel Club. I think that's one of the biggest ones. That certainly they do have a curriculum that a dog must pass in order to be labeled with their name as a certified therapy dog, so to speak. However, there are no standards as to who can become a handler. There's no standard as to what type of dog or temperament or anything. Basically, if there are some basic standards met when it comes to obedience and disposition, then most likely that person and that dog can become a therapy dog team. There's a lot of distinctions in, especially when it comes to insurance purposes and rules that kind of limit a therapy dog's usefulness in this setting. Again, the leash thing is one of them, but then also you will find in therapy dog literature, the dog's well-being must be on the same plane, on the same level as the welfare of the person that they are serving. To shift into facility dog, the selection process, first and foremost, although a number of organizations source their dogs from a number of places, the bigger ones, such as Canine Companions, where Winter came from, they're purpose-bred dogs. They're purpose-bred to become service dogs. They undergo almost 2 years of assessment and training before they're even considered for placement as a facility dog in this case. And then that placement process is very robust too. It took almost 1.5 years from the time I first applied and numerous interviews and then culminating in a 2-week handler school where you're observed as a handler, utilizing this dog, and they will not place the dog if things aren't clicking and if things aren't right. And then they've also, in the beginning, vetted who you are and their placement. Not just anybody would be able to, apply and get a facility dog from them or from similar organizations. They all kind of have their own unique vetting processes, but they all have a vetting process. And then there's a 2-week handler school. And then one of the requirements of an Assistance Dogs International accredited organization is that they provide lifetime ongoing support to the handlers. So they also, at any point during the dog's service, if there are issues, the organization has to stand behind their product, so to speak, and provide the handler with corrective measures up to and including taking the dog back for remedial training if necessary. That's just a gloss over of some of the differences between the two, but there's certainly not that vetting process and certainly not that ongoing support with most organizations that will grant a therapy dog certification versus facility dog. So hopefully that answered the question and helped clarify the difference.
Yes, it did. Thank you so much.
Thank you.
Members, any other questions? Okay, not seeing any. I thank you for your presentation. And I will go ahead and close this agenda item. And it's a good thing we weren't there because when you mentioned that the leash policy, then Winter and Tukey would have ended up in our laps. So just so you know, if
you all are
what
missing
would have
out.
happened.
You're missing out in
I
Vegas,
know,
because I'm sure
I
that's
know.
going to happen up here. It's already happened a bunch, but yeah, there'll be a big dog party
Thank
up here.
you. Exactly. Thank you so much for that. With that, we're going to go ahead and break for lunch right now. When we return, we will start with agenda item 9 from the Nevada Gaming Control. But let's go ahead and take a half-hour break. We will be back at 12:45. Hello, everyone. Welcome back from lunch. We are going to continue with our agenda. We are now on agenda item 9, which is a presentation by Nevada Gaming Control Board, including legislative priorities for the 2025 legislative session. We have the chair, Kirk Hendrick, from the Nevada Gaming Control Board, and Sebastian Ross, who is senior policy counsel for the Nevada Gaming Board. We'll give you a few moments to get yourself settled, and whenever you are ready, please proceed.
Good afternoon, Chair Miller and members of the committee. For the record, my name is Sebastian Ross, Senior Policy Counsel with the Nevada Gaming Control Board. Joining me today is Kirk Hendrick. He's the board's Executive Director and Chairman. Thank you for today's opportunity to present and update you on what the board's been working on since our last interaction with the legislature. The NGCB regulates the gaming industry and collects the industry's tax. As you know, collections totaled over $1 billion for fiscal year 2023. The piece of the pie chart near the bottom right corner represents the taxes contributed to the state's general fund. These gaming taxes contributed more than 18% to the state's general fund, according to the governor's finance office, ranking second behind sales tax. We expect financial numbers from fiscal year 2024 to be released in the near future. In order to accomplish its function, the NGCB has 6 divisions currently staffing 363 employees. For comparison purposes, in 2008, the board had 461 personnel positions, representing a considerable reduction compared to present numbers. During the 82nd session of the Nevada Legislature, the NGCB proposed and the legislature passed SB 14 that resulted in revisions to NRS Chapter 463 and the need for several required new Nevada Gaming Commission regulations. The first revision addressed administrative approval for transfers of interest to specified individuals associated with an NGC-issued licensee in the event of the licensee dying or being judicially declared as disabled to temporarily engage in activities or receive proceeds without waiting for the full process of obtaining a state gaming license. The second provision with an impact on gaming regulations addressed the parameters for NGCB access to data hosting centers, which are facilities such as Switch that may house licensee data. Additionally, the definition of gaming employee was amended to recognize evolving changes within gaming employment and the industry generally. The legislature also authorized continued funding for replacement of the board's technology operating system, which handles all essential functions for the NGCB. The contracted developer is making progress on replacing the board's antiquated system. Accelerated workflow is anticipated and necessary for the next several months. As the committee may recall, the board committed to using an incremental delivery-based model where the vendor invoices and is paid based on the percentage of work completed. The NGCB has also addressed non-legislative regulations during the interim. Pursuant to the Governor's Executive Order 2023-003 and EO 2023-008, the board identified 13 regulations for repeal, 8 regulations amended for effectiveness, and 3 amendments to update surveillance standards for non-restricted licensees. These amendments were done in an effort to eliminate and reform unnecessary and burdensome regulations. Some highlights include eliminating redundant reporting, such as the amendment in Regulation 2007-01, which now requires 1 copy of a financial statement report instead of 2 copies, eliminating reports requiring licensees to submit a monthly report on each new gaming employee hired for the preceding month, and eliminating requirements of licensees to monitor and record the activities occurring in slot change booths, as most of those are now gone from casino floors. So far this year, the board has placed 22 regulations for consideration on a public meeting agenda and recommended 16 of them to the commission. The board has conducted 3 public workshops during the past year, and we anticipate at least a couple more by year's end. Some highlights from this past year include simplifying the collection of live entertainment tax for gaming licensees offering live entertainment by implementing a gross revenue collection similar to the process followed by the Nevada Department of Taxation. NAC 368A, which provides guidance to the board on the live entertainment tax, was referred to the Legislative Council Bureau for approval. Additionally, the board modernized regulations relating to the list of excluded persons. Many of the regulations pertaining to the list had not been updated since the 1980s. The board's technology division made multiple implements to streamline the approval process. For example, the division implemented new gaming technology approval guidelines. The new approval guidelines are designed to expedite the evaluation of gaming technology. These guidelines will impact the approvals of new gaming devices, new associated equipment, modifications to gaming devices and associated equipment, and the field testing of gaming devices and associated equipment. The Technology Division also implemented the Nevada One-Day Evaluation Initiative, also known as NODE. Under NODE, the division will complete its evaluation of a slot machine modification within 1 business day of the receipt of a complete application for approval. The division's ability to complete the review is contingent on receiving a complete application that complies with Commission Regulation 14110. Additionally, the Technology Division implemented the Ante Up initiative for gaming technology field test procedures. The initiative expedites approvals by enabling NGCB agents to perform a significant portion of procedures normally conducted by a licensee, which lessens the burden on operators. Ante Up also allows the board to more quickly identify potential issues during the field test period, reducing time for corrective action by the manufacturer. As stated in NRS Chapter 463, gaming, when properly regulated, is a vital component to the state's economy. The next slide highlights gaming's financial impact. Nevada continued to record gaming win amounts in excess of pre-pandemic levels in May 2024. Nevada's May 2024 total gaming win of $1.320 billion increased 2.5%, or $31.6 million versus May 2023. The total set the new all-time record for the month of May and became the 8th highest monthly total ever recorded. Total statewide gaming win was 34.5%, or $338.7 million over May 2019. May 2024 also represented the 39th consecutive month that the state has recorded $1 billion in monthly gaming win. Fiscal year to date through June 2024, the board has collected a total of $1.176 billion, and total general fund collections are up 4.5%, or $50.1 million over fiscal year 2023. Fiscal year to date through June 2024, the board's total general fund collections are 4.4%, or $49.6 million over the May 2023 Economic Forum forecast. We anticipate full financial numbers from fiscal year 2024 towards the end of summer, so the numbers presented today are still subject to change. As we prepare for the 83rd session of the Nevada Legislature, the board is positioned to submit its biennial bill draft request to the LCB in the coming days. In line with recent legislative bill allotments, the board is finalizing 2 bill drafts with the goals of modernizing technology considerations to meet evolving industry demands and to streamline procedures to allow the NGCB to function even more efficiently. These proposals are intended to deliver reliable services to Nevada citizens and visitors. In the event that you would like to discuss our legislative proposals when BDRs are finalized, I encourage you to contact me at your convenience. Chair Miller, we appreciate you allowing us to present today. That concludes the board's presentation. We'd be happy to answer any questions that you or the committee members may have.
Thank you so much for that. Members, do we have any questions? I don't see any questions. All right, thank you so much. With that, I will close this item and we will move on to our next agenda item, which is agenda item 10, a presentation by Nevada's Cannabis Compliance Board, including an update on the implementation of legislation enacted during the 2023 legislative session and legislative priorities for the 2025 legislative session. We have the Executive Director, James Hum, from the Nevada Cannabis Compliance Board. So we'll give you a few moments to settle in as well.
Thank you, Chair. Are we ready for the presentation? Is that okay? Oh, it's not. There we go.
I shouldn't have just a sidebar conversation. I didn't realize that you had co-presenters up in Carson, so could you please introduce them as well? Thank you.
Thank you, Chair. That was actually in my opening as well. Thank you, Chair, Vice Chair, members of the committee. My name is James Hum. I'm the Executive Director of the Cannabis Compliance Board. Pleased to be here today representing the CCB to present an overview and our implementation of SB 277 from the 2023 legislative session. Assisting me today in Las Vegas is our Communications Director, Tyler Harrison. Up north, we have our Chief of Investigations, Dave Staley, and our Chief of Administration, Steve Gilbert. Just want to let the committee know that whatever measure of success I will have in this appointment will be because of them and their incredible teams who serve the state with dedication and unrivaled efficiency. As a quick background on myself and the agency, Governor Lombardo named me to lead the CCB in December of 2023, whereas in the prior 6 years, I had the pleasure of serving the state in various roles at both the Attorney General's Office and the Governor's Office of Economic Development. I must say, because of the effective and dedicated team that was in place in my time of appointment, I found the transition to be smooth. It's been an absolute joy to be in this role and to serve the state and constituents of Nevada at the pleasure of the Governor. We have already, and I know we will continue to accomplish many more great things. Now, if you will, please let me walk you through the presentation. So this initial slide is relatively straightforward and outlines the core functionality of the Cannabis Compliance Board. The Nevada Legislature set forth the public policy through NRS 678A.005, which guides the Nevada Cannabis Compliance Board's daily operations, regulatory decisions, and ultimately its core purpose and mission. Continued growth and success of the cannabis industry is dependent on public confidence and trust, which is in our NRS. Furthermore, that public confidence and trust can only be maintained by strict but fair and equitable regulation of all persons, location, practices, associations, and activities related to the operation of cannabis establishments. Continuing with the quick overview, the mission statement, Nevada Cannabis Compliance Board governs Nevada's cannabis industry through strict regulation of all areas of its licensing and operations, protecting the public health and safety of our citizens and visitors while holding cannabis licensees to the highest ethical standards. We have 4 main divisions at the CCB: administration and licensing, inspections and audit, investigations, and enforcement. Agency operations and regulatory responsibilities oversee and regulate Nevada's 450 plus operational licenses, enforce statutes and regulations set forth from NRS 678A through D and the Nevada Cannabis Compliance Regulations NCCR 1 through 15. Additionally, one of the core missions is to protect public health and safety for consumers, medical patients, and visitors to the state. We also maintain the industry's economic benefits of the state. We have 101 full-time employees, 5 CCB board members, 8 Cannabis Advisory Commission members, but I must also note that there are 4 that are in statute: myself, the Attorney General, the Director of Public Safety, as well as the Director of Taxation. Our current vacancy rate sits at 11%, but we have some additional offers out. Now for an overview of SB 277. Study on federal rescheduling, descheduling, which is front of mind now. It's coming out, at the federal level. Required the Cannabis Advisory Commission to provide a study and recommendation concerning the potential effects on the Nevada cannabis industry if cannabis were to be removed from Schedule 1 of the Uniform Controlled Substance Act or the Federal Controlled Substance Act. The chair of the CAC created a 5-person subcommittee on rescheduling, descheduling comprised of CAC members and outside experts to study and prepare this report. The subcommittee held 7 public meetings, which included a discussion with the bill sponsor, Senator Harris. Thank you, Senator Harris, for participating, as well as subject matter experts in the field of cannabis regulation. Using subject matter expertise as well as independent research, the subcommittee produced the requested report and recommendations. During the February 23rd, 2024 Cannabis Advisory Commission meeting, members unanimously approved this report. On February 29th, 2024, the final report was submitted to the LCB and the Joint Interim Standing Committee on the Judiciary. Again, of note, held 7 public meetings. Again, thank you, Senator Harris. And a thank you to former senior DAG, who's now with the county, Ashley Balducci, for her tireless work putting this report together and then thusly presenting it to the larger CAC for unanimous approval. Next slide, dealing with SB 277, environmental effects. Requires the board, before adopting, amending, or repealing any regulation, to consider whether the proposed action is likely to have an adverse effect on the environment. The repeal of NRS 678A 460 placed the CCB under the Administrative Procedures Act, and then the CCB collaborates with licensees to make environmentally conscious choices that fall within statute regulations. As to the environmental effects, Nevada's desert landscape primarily dictates that most work and cultivation happens in warehouses with internal grows. Licensees have strived to use water efficiently, as well as energy efficiently. While conversations are open with the industry, there's not a lot of push behind this, as it's a market-driven matter, and the licensees are constantly looking for efficiencies. Next slide. Dual licensing. The language comes across a little negatively, but it was a positive. CCB was prohibited from issuing or renewing a medical establishment license unless facilities are in a jurisdiction with an adult use moratorium. And thusly, the audit team has assisted facilities in merging medical and adult use inventory in seed to sale tracking systems. The transition of this project is still ongoing as the renewals are happening. And then licensing beginning January 1 of 2024, CCB staff began issuing combined licenses for both medical and adult use, creating one fee for renewal of that license. Dual licensing has functioned as intended, and the agency is in the process of combining these licenses as they come due. Next slide, individual sale amount increases. Also per SB 277, what I did here was kind of pull our listservs and our notifications to industry as well as the public. As detailed in the bill, January 1, 2024, the sale and possession limits increased from 1 ounce to 2.5 ounces of usable cannabis and from 1/8 to 1/4 ounce of concentrated cannabis. So again, these are official releases that we sent out to industry. As you can see from the slides, we notified the public as well as the licensees of these changes. Additionally, we worked proactively with industry to notify them of the changes and how this would work on the back end in their point of sale and tracking systems, as well as their signage in the facilities. Excluded felonies. This requires the board to develop and implement a process by which a person who has been convicted of an excluded felony offense may submit to the board a petition for an exemption from those prohibitions. January 18th, 2024, the CCB issued written guidance on the petition process as codified in NCCR 4150. The petitioners submit via email documentation related to their conviction, probation, and their perceived impact on public health safety in the Nevada cannabis industry. As of July 19th, 2024, 7 petitions have been received by the board. 5 have been heard by the board and approved to receive an agent card. 2 petitioners are yet to be determined pending additional document submission. As this is Judiciary Committee and given the intent of the legislature to allow people into the industry, it is our belief that this is working as intended. Of note, once a petition has been received, it has not taken longer than 60 days to get a petition before the board. Given my previous role, job opportunities are extremely important to me, and that is at the forefront of our policy to allow those that want in the industry that chance on an expedited timeline. And a few more slides, but happy to answer any questions on the excluded felonies as well. Issuance and renewal fees. This decreases the maximum amount of the fees that the CCB is authorized to charge for the issuance or renewal of an adult use cannabis establishment license. June 30th is a popular time for renewal. We are still calculating the numbers and the impact the reduction of the fees will have on our budget. As intended, though, it should have a positive impact, reducing costs for the licensees. Next was the secure entrances, which authorizes any cannabis establishment to have more than one entrance so long as each entrance is secure. Prior to SB 277, establishments could require a separate secure employee entrance if desired. Since the passing of SB 277, less than 5 facilities have requested a second secure entrance. This has been implemented, and as seen by the numbers, wasn't a particularly large number of licensees that asked for this, but the ones that have requested them, we have worked with them to allow for this. Next slide's an industry snapshot. I think many of you know facility types include cultivation, production, independent testing labs, distribution, retail dispensary, and consumption lounges. I had the team actually dedupe the cards because in some cases you can have multiple cards to work at different verticals within the industry. So the number is 14,961. So we have about 15,000 people working in the industry. Highest concentration of active licenses, as you would guess, is in Southern Nevada. 300 plus active licenses in Clark County, unincorporated Clark, Las Vegas, North Las Vegas, Henderson, Mesquite. 65 plus active licenses in Washoe County, unincorporated Washoe, Reno, and Sparks. Again, this kind of just shows the breakdown as well. Nothing specific there. This is an industry health slide. So yes, I'm sure you've heard from industry as well as constituent that the market is in fact down. This is due to a multitude of factors, economic indicators, inflation, et cetera. However, it is my belief that industry in itself is stabilizing, and this could potentially demonstrate a better representation of what can be expected moving forward. Several factors contributed to the higher numbers when the CCB was first established, given COVID and industry newness. So although the numbers are down, several items from the last legislative session, like reduced fees from SB 277, were done in an effort to reduce the burdens on the industry. This, as well as regulatory stabilization, I believe will ultimately be beneficial. Current and trending challenges, kind of covered that on the tax revenue being down. This is also consistent with sales trends in other states with more mature cannabis markets and can be attributed in part to the after effects of the COVID-19 pandemic. The illicit market, we've had a couple roundtables since I've been there, working with our partners at the AG's office, Department of Public Safety, Nevada Cannabis Association, and the Cannabis Policy Institute. Federal concerns, just in general, those are addressed more directly through the study. General look ahead. So CCB commissioned a study reviewing the economics of the regulated Nevada cannabis industry and the scope and effects of the illicit market, which will be released soon, ideally, I think actually in the next week or so. CAC Subcommittee on Market Participation. Subcommittee is working on establishing criteria for a pilot program for identifying opportunities for emerging small cannabis businesses to participate in the cannabis industry with the goal of increasing the participation of women, minority, veteran, LGBTQ+ owned businesses and local agriculture. White Pine, after the board approved regulations in February, the CCB opened their second licensing round, which closes today at 5 p.m. for one cultivation and one production establishment in White Pine County. Cannabis consumption lounges are open and expected to open on a rolling basis. 2 are currently open. And just in general, the focus of the agency will be economic growth, public safety, and government support services. So as mentioned prior, economic growth is extremely important to me given my background, and I believe that we'll accomplish this through facilitating a business-friendly regulatory environment, streamlining any licensing process, in this case, working with licensees on specific issues and making it simple for renewals. Making the culture shift at the agency has been known to industry that we'd like to create partnerships and collaborate with the industry, encouraging small business growth, which you can see kind of through our CAC. Also, the last kind of statement, government support services, we're collaborating with other agencies, as I mentioned, DPS, and also wanted to nod toward tax and HHS2 to ensure ensuring delivery of governmental services and operations to Nevada. Internally, it's certainly a tenor of knowledge sharing and problem solving across those agencies. So just kind of in closing, I guess, to encapsulate everything. Businesses have spent much of the last few years adapting to this relatively new regulatory structure. As noted prior, our goal is to provide certainty and a fair playing field for the industry to know what's expected of them and to provide stability for them to thrive. Given my newness in the role, it's certainly been and will be a year of transition where individuals and businesses can start to look forward to shaping the future of the industry rather than just grinding through the present. I was born and raised in this incredible state. And during my career over the last several years, I know this, Nevada has been and will will continue to be agile and capable of moving with urgency. Because of that, there's an opportunity for us to continue to be the gold standard in cannabis and to foster a stable, sustainably regulated industry that is capable of withstanding whatever comes. As policymakers, we must continue to pursue these ideals and maximize our advantages and remediate our deficiencies. We must keep looking forward and work together as partners. Came from an agency that always advocated hope and opportunity. And my goal is to continue on in that vein during my time at the CCB. The industry continue to be that, it will continue to be that and provide that. With that, myself and my team would be happy to take questions. Thank you again for the opportunity to be here today.
Thank you so much for your presentation. Members, do we have any questions? No? Okay, not seeing any questions. Oh,
I
the
have a
one time
question.
I don't ask. Yes, Assemblywoman, please go on.
Thank you. Mr. Hum, thank you so much for your presentation. I'm really excited to hear what you have in store for the cannabis industry. I do have a question. Is there any discussions or plans on tackling the intoxicating hemp that's being sold, I guess, illegally?
Thank you for the question, Assemblywoman. Yes, we have actually been in talks on that policy issue with the governor's office as well as industry. Somewhat as noted before on the federal side, we need to continue to look at that as we go, as that kind of develops and see if there is any more, I guess, clarity on the federal end. But yes, that is front of mind for the agency. So thank you for the question.
Sure. Yes, thank you. And then also just to piggyback on that, just the illegal sales of cannabis. I mean, the black market is booming. Is there any discussion on how you can address that issue and or maybe even partners with Metro or various agencies?
Thank you for your question. Assemblywoman James Hunt, for the record. Sorry, it's really strange. You just appear. Your face is like right there. Thank you for the question, Assemblywoman. Yes, that is ongoing. And to that end, again, just kind of a function of my newness. I've taken a pragmatic approach to that. It was almost on my first day, industry came and noted to me that had been an issue. So yes, we're talking to everyone from the governor's office to industry, as well as licensees on how and when and what that actually looks like moving forward and how we can actually tackle that issue. So that, again, like the intoxicating hemp, is front of mind.
Perfect. Thank you so much.
Thank you. Not seeing any other questions, I will go ahead and close this agenda item.
Thank you, Chair.
Thank you so much. Our next agenda item 11, is a presentation by the Nevada Cannabis Association, including an overview of its activities, an update on the implementation of legislation from the 2023 legislative session, and policy recommendations for the 2025 legislative session. We have with us Executive Director Lake Martin from the Nevada Cannabis Association. So please proceed whenever you're ready.
Thank you so much. Yeah, I'll just pull up the PowerPoint. Great, thank you. Good afternoon, Chair Miller, Vice Chair Scheibel, and members of the Joint Interim Standing Committee on the Judiciary. For the record, again, I'm Lake Martin, Executive Director of the Nevada Cannabis Association. It's my honor to be here today to provide you with updates about the status of the industry, implementation of the bills passed last session, and the outlook for cannabis-related bills in the 83rd legislative session. The NCA is the oldest and largest trade association for licensed cannabis businesses in Nevada. Our members include the majority of Nevada's dispensaries, as well as cultivation, production, distribution, and lounge licensees and affiliated businesses. Our mission is to promote a safe, compliant, and successful cannabis industry in Nevada. And we're led by a board of experienced professionals from across the industry with backgrounds in cultivation, production, retail compliance, and law. Before I dive into the current status update, I wanted to give a very brief overview of the short history of cannabis here in Nevada, basically highlighting that the first medical sales began in 2015, recreational sales began in 2017. The industry in here in Nevada is not even 10 years old. In the 7 years since adult use legalization, the industry has brought in between $100 to $150 million a year in excise tax revenue. Additionally, cannabis consumers pay sales tax on their purchases, which last year brought in an estimated $68 million. And as you can see on this slide, Nevada cannabis taxation is set up to tax at 2 points in the supply chain. Once when the cannabis grower makes the first transfer of the product to either another cannabis establishment or to a dispensary for sale to consumers. That first transfer is taxed at 15% of either the actual sales price if the seller and the buyer aren't affiliated, or 15% of fair market value if the buyer and seller are affiliated. Then when we get to the dispensary, consumers pay an additional 10% called a retail excise tax on adult use purchases. Medical customers with a valid medical card do not pay this tax. All consumers, medical and recreational, pay sales tax. The last full year of data we have available is fiscal year 2023, and in that year, the wholesale excise tax brought in $53 million in revenue, the retail tax $80 million in revenue, and the sales tax an estimated $68 million. When voters approved legalizing recreational cannabis in 2016, one of the promises of that campaign was that legalization would bring much needed funding to education. It was estimated during that campaign that legalizing cannabis would bring $20 million in excise tax annually to K through 12 education. That number has been exceeded each year by as much as 700%. Since legalization of recreational cannabis, an estimated $606 million has gone through to K through 12 education from cannabis excise taxes. That includes fiscal year 2018 through 2023. I wanted to give an idea of the full picture of cannabis taxes before we moved into the current industry snapshot. In addition to state taxes, cannabis businesses pay federal taxes, but their effective tax rate is significantly different from traditional cannabis businesses. Due to Section 280E of the IRS code, state legal cannabis businesses cannot deduct ordinary and necessary business expenses on their federal returns. So things like rent, salaries, marketing expenses cannot be deducted by legal cannabis businesses. They can only deduct costs of goods sold. So that results in an effective tax rate as high as 70 to 80%. It's obviously a tremendous burden on state legal cannabis businesses, and that's one of the key reasons why the industry is supporting rescheduling at the federal level, which I'll discuss in additional detail later on. At the local level, licensed businesses pay up to 3% of gross revenue on each establishment in the local jurisdiction in which they operate. For Clark County alone, that totaled an estimated $11 million in revenue in fiscal year 2024. As Director Hum noted, taxable cannabis sales for 2023 were $848 million. We don't have the full data for 2024, but sales are on track to be flat or declining further. Last year's sales were down $113 million from the previous year, and tax revenue in 2023 was $133 million. The continuing decline in sales year over year is obviously a primary concern for the industry. Consumers are price sensitive, and we have much competition from unlicensed cannabis and now intoxicating hemp products that are readily available at lower costs, no taxes, no ID checks. As Director Hum noted, as of June 2024, there were 462 licenses issued. Not every license is a separate establishment, and since the passage of SB 277, medical and rec licenses are merging. We have 101 dispensaries, about 150 cultivations, 100 production, 50 distribution licenses, 8 laboratories, and 2 lounges. The industry directly supports almost 15,000 jobs, as represented by the number of active agent cards. Those are required to work in the industry. Additionally, there are thousands of jobs which are indirectly supported by the industry. Those jobs which serve the licensed industry, but for which you don't need an active agent card, like mine, lawyers, tech professionals, marketing, things like that. Our economic impact report from 2023 estimated that the industry's total economic impact on the state was more than $2 billion annually, and that has to do with upstream supply chain transactions, cannabis worker household spending, et cetera. The 2023 legislative session was a busy one for the cannabis industry, and significant reforms made during that session have helped the industry survive during a challenging time. So we are very appreciative for that. Some of the notable bills: SB 195, sponsored by Rochelle Wynn, eliminated time and effort billing, enacted reasonable reforms to disciplinary violations, and required the CCB to consider self-reporting by licensees as a mitigating factor. The elimination of time and effort billing alone led to an estimated reduction of $2 million in fees annually and more communication between licensees and CCB staff. SB 328, sponsored by Rochelle Wynn and Robin Titus, put the CCB's rulemaking under the Administrative Procedure Act. It has been previously exempted from the APA. And while the rulemaking process has been slower under the APA, we have appreciated the opportunities for stakeholders to provide input and for checks and balances provided in the structure of the APA. The bill also directed the CCB to adopt regulations to enforce civil penalties against unlicensed cannabis sellers and to allow the CCB to issue cease and desist notices and to seize products. The CCB has approved Regulation 4.200, which outlines civil penalties for unlicensed cannabis sales. It's yet to come before the Legislative Commission, but we're encouraged by this step forward related to civil enforcement. AB 430, sponsored by Shea Backus, made a very important change to how wholesale excise tax is calculated. Taxation has been using a number called fair market value as the estimated sales price for all categories of products. Any product sold was taxed at 15% of fair market value, regardless of the actual sales price. Thanks to Assemblywoman Backus, this was fixed so that where the transaction is at arm's length between unaffiliated parties, the tax is on the actual sales price, not a fictional number. Also, the bill shortened the length of time for sales data used to calculate the fair market value. And as a result, we've already seen July's fair market value is much closer to reflecting actual market rates. SB 277, sponsored by Dallas Harris, was covered by Director Hum, but I did want to note that I read this morning in Michigan, lawmakers are considering merging medical and rec licenses following Nevada in that. There are significant shifts in federal cannabis policy that Director Hum alluded to that I wanted to mention because there will be some interplay between what's happening at the federal level and what's happening at the state level, and it may affect legislation as we go into 2025. Rescheduling being the biggest hot topic. In response to President Biden's request that his administration review the potential for rescheduling or descheduling cannabis, the Department of Health and Human Services has recommended that cannabis be rescheduled from Schedule 1 to Schedule 3. The DEA opened a federal comment period, which closed this week, and received more than 40,000 comments. The Nevada Cannabis Association submitted written comment in support of rescheduling, and in it we highlighted this legislator's bipartisan support for removing cannabis from Schedule 1, as indicated by the passage of Assembly Joint Resolution 8, which was sponsored by Chair Miller and Ruben De Silva, along with over 30 bipartisan co-sponsors. The primary benefit of rescheduling to Nevada's licensed businesses would be removing the burden of IRS Code 280E, and that they could pay federal taxes at the same rate as other legal businesses. On safe banking, while most of Nevada cannabis businesses are now banked, lack of access to lending continues to be a huge impediment to growth or even the sustainability of the current industry. The Safer Banking Act passed the Senate Banking Committee last fall with bipartisan support, but it's including support from Nevada's 2 senators, but it has stalled for now. The other hot topic in cannabis right now is what's referred to as intoxicating hemp. So it started with the 2018 Farm Bill, which arguably legalized synthetic marijuana federally. In the years since, there's been a dramatic proliferation of unregulated intoxicating hemp products. You've probably heard of Delta 8, and this is just one of many iterations of hemp products which are being chemically altered to have psychoactive effects. Congress is considering an amendment to close this loophole in the Farm Bill that has allowed these to proliferate. The concern with these products is they're not regulated, they're not tested, they're not age-gated, they're available broadly. Nevada has some stronger prohibitions than what it's in place in the federal level, which we'll discuss in a moment, but because we're dealing with a federal loophole, there's little we can do to stop the deluge of products available online. In 2021, this legislature prohibited the sale of synthetic cannabinoids. It was one of the first states to really address this intoxicating hemp issue, and required Delta-8 to be sold only in dispensaries. It effectively stopped the flood of Delta-8 products into Nevada for some time. However, now there are more online retailers and more variety of products that fall within various loopholes, and so we're absolutely seeing these products show up on smoke shop shelves. As for the 2025 legislative outlook, broadly, we're looking at 3 categories: streamlining operations, unlicensed sales and intoxicating hemp, and growth and sustainability of the industry. Under streamlining operations, because so many of the foundations of the licensed cannabis industry were set up by the legislature in statute, every couple of years we have to come back and ask for little tweaks to things that we've outgrown or need to be changed to keep up with this ever-evolving industry. Things like streamlining agent cards, things like increasing packaging sizes, some technical issues that we'll likely have this year as well. On the issue of unlicensed sales and intoxicating hemp, unlicensed cannabis sales continue to divert revenue from legal taxable cannabis sales. Additionally, unlicensed companies target tourists who know that cannabis is legal, but don't realize that licensed companies are zoned out of the resort corridor. Unlicensed companies offer online sales and direct-to-hotel room delivery of illegal cannabis, frequently brought in from California. We're hopeful that the CCB's recent steps towards civil penalties for unlicensed sales will lead to much-needed enforcement, but to be clear, this remains a substantial threat to a struggling industry. Intoxicating hemp sales similarly are diverting sales away from taxable cannabis products, offering the same high at a cheaper cost. They're available all over the Strip, in smoke shops, off of Instagram, and without requiring customers to be 21 to purchase. So our goal is to make it easier for law enforcement and the CCB to get these products off shelves. If we can't prohibit them because of the sheer volume, the next best is state regulation. Excuse me, requiring them to be sold in licensed dispensaries in the same manner, with the same testing, ID verification, and taxes as cannabis products. Under growth and sustainability, the cannabis industry in the state is declining, not thriving. We're not alone. A recent economic report came out saying that only 25% of cannabis companies nationwide are profitable. And that's because of the same issues that I've outlined here today, that they're facing these across the country as well. Access to lending, a lack of investment, can't cross state lines, 280E, and the unlicensed cannabis sales are challenges that cannabis companies are facing across the country. And we see them here as well. So I expect you'll hear a few concepts next session aimed at growing the opportunities for sales. In closing, I wanted to highlight that the $600 million that the industry has sent directly to K-12 education accounts for only 6 years of sales. I can predict with confidence that we will send $1 billion from cannabis to K-12 education by the 10-year anniversary of legal cannabis sales. Thank you again for allowing me to present, and I'm happy to answer any questions.
Thank you. Members, do we have any questions? I don't see any questions. So with that, thank you for your presentation. And we will move on to our next agenda item. This will be a fully virtual presentation. We have a presentation on the activities of the Cannabis Policy Institute. We have Rihanna Durrett, the director of the Cannabis Policy Institute out of UNLV, and Marla Stafford, PhD, research director for the Cannabis Policy Institute, also from UNLV. Is Marla joining you?
Yes, I'm here.
Okay, now we see you both. Okay. So whenever you two are ready, please proceed.
Hi, Chair Miller. Thank you so much. I also need to upload a PowerPoint. Can you see the screen?
I don't know if you've been tuned in all day, but we're all kind of adjusting to the new technology because we're in the new building, so it changes all the time. We see you right now. We have experienced that when people are in Carson and the person starts speaking, then the screen goes to them, but we have a lot of different new things going on. So now we can see your PowerPoint. I don't know if you go full screen, if we're going to lose you two, but if we do, then I'll just let you know to come back because we like looking at y'all too. So.
Okay. I think we're off to a good start then. Okay, great. Thank you.
Oh, perfect. Yes, perfect.
Thank you. Okay, thank you again. Thank you for allowing me to present, Chair Miller. Good morning or afternoon, Vice Chair Scheibel, members of the Joint Interim Standing Committee. For the record, my name is Rihanna Durrett. I'm here to introduce the UNLV's Cannabis Policy Institute, where I serve as the executive director. UNLV created the Cannabis Policy Institute almost a year ago with the mission to expand, coordinate, and promote cannabis education, policy, and research. UNLV is a great fit for this endeavor because it has an R1 designation as an R1 research institute by the Carnegie Foundation. I was excited to be selected for this position given my work in the cannabis industry as the director of the Nevada Dispensary Association, and then my service on the Cannabis Compliance Board, where I continue to serve as the vice chair, as well as my work developing the state's first cannabis law and policy class at William S. Boyd School of Law. I am assisted by a very accomplished board that provides guidance and expertise, including the provost of UNLV, the dean of the law school, Dean Grinfald, the chair of the Clark County Commission, Tick Segerblum, the dean of the medical school, Dean Kahn, vice president of research, David Hatchett, cannabis cultivation owner and attorney, Judah Zakalik, the director of the Center for Economic and Business Research, Andrew Woods, and dean of Greenspan College of Urban Affairs, Robert Ulmer. My team includes myself, a director of research, Dr. Stafford, who's on with me today, 2 doctoral students, and 2 interns. Dr. Stafford has a PhD in marketing, but she also has a much broader range of research experience and academic work, including responsible gaming, developing a gaming code of ethics, social issues in advertising, and health messaging, among others. The Institute has been off to a great start over this past year. We've initiated several cannabis research and policy development projects already. Dr. Stafford and I will briefly summarize those policy and research projects, but first I'd like to highlight some of our other accomplishments. We launched a speaker series hosting panel discussions and webinars on important and developing cannabis research and policy topics. We published articles in the 9th Circuit Western History Law Journal, the Nevada Lawyer magazine published by the State Bar, and we have a law review article pending. We have received local and national news coverage for our efforts. We worked on a planning committee for the Institute of Cannabis Research's annual Cannabis Research Conference. And this is a conference hosted in Colorado annually and attracts researchers from around the country. We participated in peer reviews of proposed cannabis research project grant requests. And as a result of this initial productivity and engagement, we were invited to join with other universities in on a National Institute of Health grant request for funding to create a national cannabis resource center. So we were invited by these other universities to participate in that. That is currently pending with the National Institute of Health. So we've already begun to fill the great need for translating cannabis research into policy information to assist in informed decision-making. You often hear that there's no cannabis research. There is limited and delayed cannabis research given its federal prohibition, but there is cannabis research ongoing throughout the country, and there really is a need for promoting it, disseminating it, et cetera. We've worked closely with the law school in order to expand their cannabis course offerings. And the Institute itself has become a center for education as I supervise 2 graduate students and 2 interns, as I previously mentioned. I'm just going to touch on some of the policy projects we are working on, but of course, I'm always willing offline to provide more detail to anybody that's interested. First, I've teamed up with Dr. Goldstein, the author of Can Legal Weed Win and director of cannabis economics at UC Davis, to develop reports on Nevada's cannabis economy, and also a report shedding light on Nevada's future and really when cannabis sales can be conducted across state lines. That would have a great impact on Nevada's cannabis market. I'm working with Dr. Stafford and policy experts to devise a national code of ethics and standards for cannabis advertisements. The rules vary state by state, and they would benefit from research that has been conducted since after the time they were originally adopted. And this is the case in Nevada as well. I'm working with the former director of the CCB and co-founder of the National Cannabis Regulator Association to publish a report on hemp beverages sweeping the nation. These can be delivered to doorsteps in many states in the United States and may potentially have a big impact on struggling cannabis markets. And finally, I'm working with Dr. Stafford and cannabis policy expert Christina Dempsey, the founder of the Cannabis Policy Lab, on a cannabis policy report to be prepared for the upcoming legislative session. Future areas of interest for cannabis research and policy development that I believe are important to Nevada and that could be conducted at UNLV include state regulation, economic development, the impact of federal changes to Nevada's cannabis markets, social equity and inclusion in the cannabis industry, public health impacts, medical research, prevention of youth cannabis use, the relationships and intersections of cannabis with gaming, and cannabis tourism and hospitality. If it's okay with the chair, I'm going to ask Dr. Stafford to cover our research projects, but I wanted to just very quickly give an update on DUI and impairment laws as the chair requested. According to a report published in the National Institute of Health's library in 2022, there is, quote, no validated behavioral or biological marker of recent cannabis use or cannabis-related impairment, end quote. So basically, the bad news is that we don't have a reliable method for DUI impairment, even though we've heard that the research is ongoing. But the good news is there are well-funded research projects ongoing at UCSD, various Colorado research institutes. They have not established a reliable way to determine cannabis impairment because what they're coming up against is that THC does not reliably indicate level of impairment. But they are confident that they will eventually be able to develop a system for more reliably determining impairment. Again, there's a lot of funding going into this research, and they are making progress, and they are developing the data necessary to eventually be able to recommend a test for impairment. And if you would like any more information about the state of impaired driving laws, including in Nevada, I will have a report on this prepared by a student that will be on our website very soon. And now, if it's okay with the chair, I'd like to ask Dr. Stafford to summarize our research projects.
Thank you, Rihanna, Chair Miller, and Vice Chair Scheibel. Rihanna, is it possible just to move forward a couple of those slides where we do have some highlights of the research projects? I'm really excited to see the range of cannabis research projects that are happening here at UNLV, and I'm really excited to share with you some of these very diverse projects. Cannabis covers a lot of different areas. So, for example, tying to the policy report Rihanna mentioned earlier on advertising, I'm also involved in projects related to ensuring responsible advertising in cannabis, with specific emphasis on protecting children who are a vulnerable population. Right now, I'm working with a researcher at the PHI to determine those factors attracting children the most. And these results will have an impact on the policy report that we produce on advertising. We will also submit it for publication, and I will also be presenting on this topic at the upcoming Cannabis Research Conference that Rihanna did mention. Another research project examines the topics, the people, the professions, and the timing of posts on X, formerly known as Twitter, over a period of 10 years. This particular research provides insights into who is discussing cannabis, when and what they are talking about, and what this means for reaching certain groups of consumers. The results offer implications into the demographics, into the interests of actual cannabis users, and what this actually means for both marketing and public policy. Dr. Landers at UNLV and his team is investigating cannabis and Parkinson's disease. Specifically, they are exploring the effects of THC and CBD on self-report balance problems, as well as the freezing of gait in Parkinson's disease. They've actually already analyzed existing data, and they found significant differences in self-reports of balance problems among the different types of cannabis products. To learn more, they are in the process of securing investigational new drug approval from the FDA to conduct further studies. In a different area, Dr. Park and his students sought to develop a virtual reality youth drug prevention program to improve youth's resistance skills and awareness of drug use risk. They actually used an experiment to investigate VR technology in youth education regarding drug use prevention, and they found that VR technology is more effective than traditional methods, and that VR has a meaningful impact on youth drug prevention. They are looking to expand this research in the future, as obviously these results have significant implications for policy. Dr. Erickson, who was in the sociology department, he and his team are examining motives of initiation and patterned use, the perspectives of users on changes in legal policy surrounding cannabis, as well as the impact of cannabis on users' physical, mental, and social health. Results will inform the development of beneficial policy and public health practices related to cannabis. And I might also add that he and his team are applying for research with the National Institutes of Health. And this is just a sample of projects that are going on. We have a project on cannabis and gaming. We have a number of different projects across the university, and we're very excited about the current work and future work, as this body of research will have significant implications for cannabis policy. So I thank you so much for the opportunity to present the research at the University of Nevada, Las Vegas today. And of course, I also am available to answer any questions. So thank you.
Thank you so much. Does that conclude your presentation?
Yes.
Yes. Thank you. Sorry.
Okay. Thank you so much. Members, do we have any questions? Vice Chair Scheibel.
Thank you, and thank you both for your presentations. I'm sorry, I don't have the slideshow in front of me. Did you say that there was also research into impaired driving incidents associated with cannabis use?
Brianna, do you want to?
Yeah, good afternoon, Vice Chair Scheibel. We don't have research on the number of incidents. What we have done is prepared a report on the status of impaired driving laws, as they've been sort of in flux, including in Nevada. So the research is on the research. What's happening with the research?
Okay, got it. Thank you.
And I can provide that report to you. I can email it directly.
Thank you.
Thank you. We look forward to a report on the report. So thank you so much. Members, are there any other I know there's a delay between our electronics right now. Members, any other questions? All right, not seeing any. Thank you for your presentation, and I will go ahead and close this agenda item.
Thank you so much.
With that, yes, thank you. We will move on to our last presentation for the day. We are going back to agenda item 8, which is a presentation on the activities of Nevada Governor's Council on Developmental Disabilities, including policy priorities for the 2025 session. We have Catherine Nielsen, the Executive Director of the Nevada Governor's Council on Developmental Disabilities, and she will be presenting virtually. And so right now we have, Dr. Stafford, we still have you on Zoom. So
I thought I had turned that off. My apologies.
That's okay. We just and so Director Nielsen, when you're ready, please proceed.
Wonderful. Can you all hear me okay?
Yes, we can.
Fabulous. First of all, thank you, Chair Miller and Vice Chair Scheibel, for allowing me to be moved in the schedule today to the last presentation. I was with Congresswoman Titus and her staff in DC advocating for Nevada. So I appreciate the opportunity to be here and speak with you all. Let me see if I can go ahead and share my screen. that full slide up. So we all love technology. Okay, so I'm going to be talking to you guys about guardianships in Nevada today. I know that a couple of presentations went over some of the information that I have in my slides, so I'm going to do my best to skip over those pieces to give you guys back some of your time today. What we are going to be talking about is obviously there are 4 different types of guardianship, and those were briefly discussed. And the biggest piece that we'll be talking about is the guardianship that involves individuals with intellectual and developmental disabilities, whether they're a minor or an adult. So there are actually a couple of primary pipelines for guardianship that we've discovered through a lot of the different conversations that we've been having, primarily nursing homes and students that are transitioning out of high school. And that seems to be a majority of guardianship cases that we currently have in our state. That's not the only pipelines, but those are just 2 of the primary. There are alternatives to guardianships that several of you worked to pass a couple of legislative sessions ago, and that is obviously the supported decision-making agreements. Throughout the last couple of years that those have been becoming increasingly popular in our state, they have, again, gained in popularity, but has also increased a lot of questions within the community that we hope to provide a little bit of clarification in our presentation on. So we did actually talk with a couple of different community members, and we sent out a brief survey to talk to them about what their thoughts were on guardianship from the community. Many people felt that it was really supportive when it was used appropriately, that unfortunately it can very often be used inappropriately, that there's not a large amount of information on what guardians can and cannot do once they have been granted guardianship. And then there's also not enough information on what the protected persons can and cannot do. And I mentioned specifically voting because there's a lot of misconceptions that individuals who are in guardianships cannot vote. They can retain the right to vote and are able to do so in Nevada. There is not a whole lot of information about transitioning off of guardianships as well, and how to ensure that supported decision-making is kind of built into that, but that is something that we're working on with a lot of different agencies, and we have a website that I'll mention as well for that too. But again, guardianships have actually been reducing in numbers over the years because we've found good alternatives like supported decision-making. I heard somebody mention that if somebody can choose where they want to live, they should be given the right to choose. And that's in pretty much every instance. And I think more individuals are becoming much more knowledgeable on what that looks like, and how they can guide and help provide support for those that maybe need a little bit of somebody to bounce ideas off of or somebody to help support their decisions. So again, the number of guardianships in Nevada have been going down over the years. So we also asked about the community thoughts on supported decision-making as well. Not enough people know what it is and what it is not. And primarily, it's not a whole lot of people outside of the disability community. Doctors' offices, banks, and I mentioned institutions, not knowing what it is, but we're talking hospitals, any kind of outside business. And a lot of them don't honor the document. And I think it has to do more about fear. They don't want to do the wrong thing. They don't know how valid the supported decision-making guardianship agreement, or I'm sorry, the supported decision-making agreement is. There's concern that because doesn't need to be notarized, or there's not a standardized form, they just don't know if the form they're being provided is correct. And I think that just has a lot to do with us continuing to provide education and resources in the community. We have also heard that there is really a lot of benefit to creating standardized forms for these types of agreements, but there's also the other side of the argument that this agreement should be whatever the individual wants. And so there is kind of that caveat of creating standardized forms kind of makes it that they have to follow this form and negates that ability. So A lot of other individuals feel that supported decision-making agreements are really only appropriate for those labeled as higher functioning. That's not true. Many individuals can benefit from supported decision-making if they can decide what they want to wear, what they want to eat, where they want to live, then supported decision-making can absolutely be utilized. Some people feel that supported decision-making should be in place for all adults with IDD, including those that are currently in guardianships. And so even if somebody is in a guardianship, we encourage the use of supported decision-making as often as possible. There are instances where guardianship comes into play for some individuals when it comes to maybe their health or their financials, but even in those instances, we encourage the use of supported decision-making. So some considerations for change, and I'm sure this is what you guys are looking for here, education to the community on least restrictive options. So that's something that we'll be working on to help provide as many opportunities for education and resources as possible. But when it comes to current laws for guardianship, there isn't a whole lot of conversation about supported decision-making in the law. There is really not transition plans into adulthood, so transition plans for minors or the minor protected persons transitioning into adulthood, including any conversation about supported decision-making. And so we want to make sure that while guardianship is appropriate for some individuals, that supported decision-making agreements be built into the laws so that more people feel confident in utilizing supported decision-making as their option. We also encourage transition plans for adults in guardianships to transition to supported decision-making agreements. There are many parents that have come to us saying, I used to be a guardian because supported decision-making wasn't a thing when I took guardianship. And they've worked to transition from being their guardian to no longer being their guardian and utilizing supported decision-making. The law that was passed has really helped to benefit people feeling more successful in their supported decision-making agreements as well. So again, the current laws don't really provide information on alternative specifics to supported decision-making agreements in a way that helps other entities feel confident in these agreements as well. And then we'd also like to see the addition of supported decision-making education into various settings, including law schools, where they talk a lot about guardianship and rights of individuals. IEP meetings, we'd like to ensure that IEP meetings, because that is one of the pipelines to guardianship, that they are exploring supported decision-making. Many parents have stated that when their child's transitioning into adulthood and they're getting ready to leave high school, they're presented with the conversation of guardianship. And so we're hopeful that continuing to provide the education that they might be presented the opportunity for supported decision-making instead of that. And so we really want to see that kind of take place. And then annual medical exams as well when it comes to working with pediatricians and those that are primary care providers for either adults with disabilities or maybe even children that are getting ready to become adults as well. And so we want to continue to provide education. So that's something that we wanted to let you guys know that we're continuing to do. We do have sdmnevada.org, and that is the supported decision-making website that we put together with the University of Nevada, Reno's Center for Excellence in Disabilities. So we are extremely excited that you all are considering any sort of change to guardianship to allow for as many opportunities for these individuals to make their own decisions. So I believe that is the end of my presentation. I'm going to stop sharing. I hope I didn't repeat anything so y'all can get back to your day as quickly as possible, but I'm ready for any questions you may have.
Thank you so much for your presentation. Members, Vice Chair Scheibel has a question.
Thank you so much for this presentation and for reviewing this information with us. I do remember having a couple discussions about supported decision-making at the legislature over the last few years. And something that kind of came to me while you were speaking that I don't think we've discussed before is, especially when you were talking about providing more kind of I think what you're saying is providing more guidance in the law for people who are interested in developing a supportive decision-making agreement instead of a guardianship relationship. Do we have, could we create, does there already exist like a, I don't want to say a standardized, but maybe a template form for a supportive decision-making agreement?
So thank you so much for the question, Catherine Nielsen. For the record, Vice Chair Scheibel, we don't currently have a standardized form. And I think that that was kind of built into the law as a way to say you can make this agreement be whatever it is that you want it to be. But that has also kind of created the concern on the other side that when you come to the bank or whatever with this form, they're not quite sure whether or not this is something that is legal. Was it done appropriately? The way that those agreements work right now is the individual will make all the decisions with their identified supporter or supporters, and then they need 2 witnesses. It doesn't currently need to be notarized. It doesn't need to be filed with any court system, and there's not a current standardized form. So our suggestion would be that we create the standardized form so that there is more there's more trust within the community that this is legitimate and this is something that they can trust to utilize with the appropriate measures.
And if I can follow up, is that something that the department would administratively be able to handle if, you know, they were tasked with being the repository for those agreements, maybe not requiring them to have not requiring them to approve them or anything like that, but just having a standardized form that you fill out, you put your agreement in there, you sign it, you send it back to the department? Or would that be unhelpful?
Catherine Nielsen, for the record. Vice Chair Scheibel, I'm not sure if that's something that the Department of Health and Human Services would be able to take on. The biggest thing is that current guardianship, where they hold those records and file them within the court system, really allows there to be some sort of legal document that says this is valid. And so if we were to make the requirement be something along the lines of we need it to be notarized, or if we created an example form that kind of provided the guidance and started to utilize that, that would be much more beneficial. It's the premise behind it is that if you decide you want a supporter, you've kind of had that conversation. But I think we've all kind of talked about where that might live, and it's still up for discussion on that.
Okay, I appreciate that. Thank you.
Any additional questions, members? Okay, not seeing any. Thank you for your presentation, and I will go ahead and close this agenda item. Thank you so much. With that, we will, I'm sorry, continue.
I just said thank you. Thank you so much.
Thank you. Have a good weekend. With that, we have concluded all of our presentations for the day, and we will move on to our last agenda item, which is public comment. So again, the phone number, if you wish to dial in to make public comment, is 1-888-475-4499. And the meeting ID is 812-6374-3353. Starting here in Las Vegas.
Assemblywoman go off their dog.
Ms. Nilsson, I believe you're still on the Zoom. Okay, I think she's gone. Okay, Assemblywoman, you're fine with your dog.
She just got back from the groomer. She was happy to see me.
I mean, we've had dogs throughout today's meeting, so it's quite all right. Again, is there anyone here in Las Vegas that wishes to make public comment? Not seeing anyone. Is there anyone there in Carson City that would like to make public comment?
Yes.
So okay. Oh, welcome. So I don't know if you've been paying attention all day, but we're in our new building and new technology that we're all adapting to. And Carson doesn't show until someone speaks. So I was literally just going to say, if you are there, please speak. So, but you're there, so please continue with your public comment.
Thank you, Chair Miller. I'd like to call your attention to SB 153 from the 2023 session. SB 153 directs the Department of Corrections to draft and implement policies for appropriate standards for meeting the needs of transgender, gender nonconforming, non-binary, and intersex persons who are incarcerated. These regulations cover appropriate housing, commissary access, personal items, and access to medically necessary health care. The bill purposefully gives the Department of Corrections broad discretion to create pathways for individual assessments of those within the system, taking into account the risks and needs of the individual, the population under consideration for housing location, and the demands for the safe operation of a prison. To date, I have seen no evidence of progress on these regulations. Section 9 of the bill requires the Director to adopt and implement the revised regulations by January 1st, 2024. That's over 6 months ago by my count. Please note, prior to the close of the 2023 session, I personally delivered the California Department of Corrections and Rehabilitation policy, for which protects the transgender, non-binary, and intersex people incarcerated in California, to the Director. I also provided the contact information for those working with the California Department of Corrections and Rehabilitation who were eager to share their experience of what was and was not working, so that Nevada could be able to have a more efficient and practical starting point for regulation development. I suggested, Chair Miller, to add to the next meeting agenda a report from the Director.
I need to ask you to wrap it up because of the time.
Simply add to the next meeting agenda a report from the Director of the Department of Corrections on the development of these regulations and learn why there has been a delay. Thank you.
Thank you. And Brooke, with that, if you have, first, we all know you, but for the sake of the minutes, we need to have you identify yourself. State your name for the record. And also, remember, if there's any additional comments that you had, please submit them in email to us so that we have all of your comments. But please identify yourself.
Brooke Maylath, representing myself. That's BROOKE MAYLATH. And I thank you for your consideration.
Thank you. Looks like someone else is there in Carson City at the counter with you. Okay.
Good afternoon.
Yes, please proceed.
Tanya
Hello.
Brown. Hello, everybody. Tanya Brown, Advocates for the Inmates and the Innocent. Tanya Brown, TONJABROWN. I wanted to, I'm here going to discuss something that was brought to my attention, and they asked that I bring it to your attention. And this deals with the county administrator or the county recorder. Okay. Now, this had was brought to my attention about when a person dies and there are no heirs, none whatsoever. I was told that in Carson City there were 3 instances in which someone died, there were no heirs, and there was a lot of money. We're talking millions of dollars, and you may have heard about that, about the man who passed away and all the gold. It was millions of dollars worth of gold, and then they found an heir. According to him, they found an heir, a distant cousin, and then the recorder, the county recorder, wound up receiving part of the inheritance or part of the proceeds from the sale of everything. And then I was told that there was another, a different county recorder. Oh, okay, thank you. Sorry, county recorder. Whose job was to locate the heirs. There were absolutely no heirs, and that they had a lot of property here in town, and it was sold, and it sold for millions of dollars. And the money went to the recorder for her own personal use. And so they said that the law, they wanted you to know, to look into the law about those who pass away, who have no heirs. Where does that money go? And we agree that the money should go back into the county to help those in need. And so when you were talking about the guardianships and stuff like that, that brought to my mind about this. So can you look into that and see? I will tell you, the person who told me this was a public official. And so I kind of want to take what he said to be true. I did look online, and it says that the money goes to the representative. Well, they become the representative. So basically, you're saying that if this person comes in, if it's a public official or whatever, becomes a representative, there's no money. At the end of everything and everything is paid, he gets to keep it. So there could be millions of dollars involved. Thank you.
Thank you so much for that. Doesn't look like there's anyone else in Carson City making public comment. Are we correct? No one else? Okay, with that, broadcasting, is there anyone on the line that would like to make public comment?
Thank you, Chair. If you would like to participate in public comment, please press *9 now to take your place in the queue. Again, if you would like to participate in public comment, please press *9 now.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office in 2015 during a mental health crisis at the Peppermill Casino, where he asked security for help. Instead of help, Reno Police showed up and hogtied him, dumped him at the Washoe County Jail cell, hogtied him, and asphyxiated him to death. There is absolutely zero oversight of county jails in Nevada, and I would like, personally, as a private citizen, I would like to see some BDRs and bills created so that there is oversight of the county jails, because people are dying there from abuse, torture, lack of medical care, and I do think that you all should support a bill, the Medical Civil Rights Act, which you could model off a bill that was presented in Massachusetts. It sadly didn't pass, but it should pass in every state. In some states, police dogs have a right to medical attention, but human beings interacting with law enforcement don't. People at the county jail are denied basic medical care, and that's not okay. So I would like you to consider using some of your bills to get oversight of the county jails so that no other families have to have a loved one die or be murdered at the hands of deputies at a facility. Thank you.
Thank you for your comment. Broadcasting, next caller.
Chair, you have no more callers wishing to participate at this time.
Okay, thank you for that. So then we will move on to our last item, which is adjournment. Right now, our next meeting is scheduled for August 30th. We will have the meeting on August 30th, but it's really more of just a work session for us to vote on which ideas we would like to move forward into bill draft proposals. And I just want to reiterate the date that August 7th is the date that we are requiring everyone, notice I use the word requiring, not requesting. We are requiring for everyone to have their ideas and suggestions into LCB so that we have time to review. So please make sure you get that in by August 7th. And we will meet again on August 30th for that work session. At this time, Nellis states the meeting will start at 9 a.m., but please pay attention. We may be having a half day starting around noon. So we will have that updated for you at least a week or two in advance, but just know the possibility of that. And with that, if there's no further anything else going on, this meeting is adjourned. Enjoy your weekend.